My lord, I am praying for listing a matter, my lord. My lord, in this case, my lord, some articles will be seized by the police, my lord, without giving any, my lord, seizure list. Where's for years?
Article seized. Why should it be a bench for matter? So what is you want to release that?
My lord, I have filed an application, my lord. Read petition, my lord.
Read petition.
Yes, praying for my lord, direction to the respondents. That is my lord SP and to see, my lord.
No, Mr. Counsel, some seizure has been made in a criminal case.
No, my lord. Some articles have been seized by the police, my lord.
In what? In a case? In a case or just like that? They just
No,
seize it for the
nothing.
fun of it.
No, my lord. Without any rhyme and reason.
No seizure memo given.
No, nothing.
That's confess. No, you see, because I'll tell you the matters I can take up. Bench 4. A writ petition civil relating to settlement by state government, etc. pertaining to civil bench 4. Residuary writ petitions pertaining to civil bench 4. Writ petition civil relating to tax matters. A writ petition under civil labor and industrial law arbitration matter. Let me see where you can go. Let me see. I don't know where you'll go.
My lord, that is related to bench 4 matter. Earlier, my lord mentioned this case in another court, my lord, bench 4 matter.
No, I don't have a problem. It provided it is a bench 4 matter. When did you find Monday?
Yes, please.
Monday.
Please.
Please, Your Lordship. Lord, I have filed one IA for vacation of the stay order, my lord, but it was not listed. The can it be listed on 18, my lord? Wait, please.
Okay.
I am applied. Item number 13 is 18 is Friday, I think.
February 18 is Sunday.
19.
Wait, please. Item number 13, my lord, I have filed an affidavit on behalf of the private respondent number 4, as per your lordship's direction, my lord. I will be allowed to bring the same on record, my lord. All right.
May I pray for listing a matter relating to assessment bill, my lord. APDCL authority has assessed the bill, my lord.
Huh?
APDCL matter, my lord. APDCL has assessed.
Pending matter.
No, my lord. I have filed it on 1st of February, my lord. Yet still the matter has not been listed, my lord.
Not listed.
Yes, my lord. Tomorrow, my lord.
No.
My lord, otherwise electricity may disconnect, my lord.
Maybe disconnected.
Yes, your lord.
You have not paid your dues.
My lord,
Whether AP this matter, the bench 4 matter.
yes, my lord.
Okay. And tomorrow, how many matters have we got tomorrow? And we have got the supplementary also. In the main list, with supplementary, it will be too much. Next week.
My lord, it will not take much time, my lord.
You filed it in 1st February.
Yes, my lord.
Today is what date?
8th, my lord. I am
Okay.
waiting, but leave not
Okay,
this.
tomorrow.
Apply to
May I please, Your Lordship? The concerned others are beg to mention item number 4, Your Lordship.
Yes.
In this matter, the department would like to file an additional affidavit, Your Lordship.
Would you like to file a?
Additional affidavit, Your Lordship. We already filed one affidavit. We'd like to file another one, Your Lordship.
Your father?
I'm for the Forest Department, Your Lordship.
You want to file additional affidavit?
Yes, Your Lordship.
Who's for the petitioner? He's not here. You have not.
We have taken consent, Your Lordship.
Where? You've taken consent.
Yes, Your Lordship.
Who?
Consent taken.
Whose consent did you take?
It was Mr. Who, Mr. P. Mohanto.
Mr. Mr. R.R. Gogoi, Learned Counsel for the Forest Department, prays for adjournment and submits that he wants to file an additional affidavit. full stop. He also submits that he has taken the consent of Mr. P. Mahanta, Direct Counsel for the petitioner. Accordingly, list the matter after,
On 27th, your lordship.
list the matter on 27.
Obliged.
Wait, please, my lord. I beg to mention for listing of a tender matter today, my lord. The similar matter is listed today, that is item number 22, my lord. Of supplementary list.
It's a new case.
Yes, my lord. From motion. Highly obliged.
Yeah, on the same party,
Same party, my lord.
May it please your lordship, a prayer for listing of a
Today,
writ
today.
petition.
Huh?
A prayer for listing of a writ petition 5029/2021 for admission be kindly be allowed to be listed on next week.
21 matter, madam, for what? What is the issue?
Your lordship, there has been an undisputed amount between the petitioner and the respondent number 2.
Who is the respondent number 2?
Your lordship, we are the respondent number 2.
You are two private individuals,
Yes, lordship.
and you are before this court.
Your lordship, actually, the respondent number 1, which is Micro and Small Enterprises Facilitation Council, had already ordered to pay, has,
Give a date.
Lordship, I beg listing this matter for motion. This matter relates to non-payment of contractual dues.
No hurry. When did you finish your contract?
Lordship, last posting is 29/2023. Last.
Give a date.
Okay.
If I had WTC for listing on 16/2/24. Tender matter, it was last listed on 17 days ago. And it was supposed to come after 3 weeks. Promotion.
What tender? Market?
Or no, even.
Huh?
No, even in the in AMC is
Huh?
in AMC is.
Okay, it's a normal tender. For what?
For cleaning.
Cleaning.
Cleaning and sanitation.
Give a date. Yes,
May I please your lordship, I pay for listing of a case for admission in a pending matter, lordship.
give a date.
Similar prayer.
Yes.
Lordship, prayer for fixing the matter at 2 PM, Lordship, item number 7.
7. Okay. 7 and 8. There will be 7 and 8.
Another one.
May I please your lordship, I beg to mention item number 5, lordship.
Yes.
My senior is not well today, lordship, may I adjourn the matter.
Yeah, huh?
Item 5, lordship.
Your senior is not there. Who's the senior?
I am saying, lordship.
So give me item 5. Yeah, not in a hurry, okay. On the prayer for adjournment made on behalf of Mr.
I Hussain.
Huh?
I Hussain.
I Hussain, counsel for the petitioner. List the matter after. Is there any stay order?
No, lordship.
List the matter after 3 weeks. List the matter after 3 weeks.
May I please, Lordship, I beg to mention for listing to contempt petition.
Huh?
To contempt petition for orders.
No. Give a date.
Obliged.
Yes.
May I please, your Lordship, I will be allowed to withdraw this petition.
What is your name?
Yes, yeah.
Miss S.E. Ahmed, National Counsel for the petitioner, present to be allowed to withdraw the writ petition. Mr.
R. Sharma, Lordship.
R. Sharma appears for
Respondent number 5.
this point number 5. The prayer of the petitioner's counsel is allowed. A writ petition is dismissed as written.
Abhilash Raj.
Yes,
Lordship, as per the 9-5 agreement, Lordship, for the last 8 months,
let
Lordship.
me see 9-5, is it an agreement?
Yes,
Page,
page 19, Lordship.
page 19.
Lordship.
Yes,
The Lordship, as per this 9-5 agreement, Lordship, we are supposed to pay the amount 30 lakh 70,000 in 25 equal installments.
Huh?
Till December, Lordship, we have paid.
just a minute, 9-5, it is not an agreement. Where does it say it's an agreement? Agreement has to be executed by both the parties.
Yes. This is by the Eastern PF Commission.
Huh?
This is by the letter given by the Eastern PF Commissioner recovery.
Correct, this is not an agreement.
It is a settlement, Lordship, for installment payment, Lordship. And on 17-5 also, Lordship, the original, you will find that page.
There's a lot of
Yes.
sound coming from the court. No, let them continue. We'll hear them. After they finish, yes. Lot of sound coming. It's disturbing the concentration. Please lower your volume. Okay, it's disturbing us.
Lordship, in continuation of the 9-5 agreement, Lordship, there was another letter on page 23, 17/5/2023,
Look, with reference to your letter,
Lordship.
your request, so your proposal had been accepted.
Lordship.
Okay, it is not an agreement. Now, what has happened?
Now, Lordship, in terms of this settlement, Lordship, we are supposed to pay 1,53,993
Per month,
per month.
then,
And till December, Lordship, this if 1,53,900 is multiplied by 8, it comes to 12,31,900.
no, so you have been paying this amount
Lordship,
from which month to which month?
from May, Lordship.
From May
December.
to
May to December, Lordship.
May to December 23.
Lordship.
Then,
Lordship, they have also admitted, Lordship, that we have paid 12,69,959 by
12 lakhs,
12,69,959.
959.
59. Now, Lordship, the interim notice has been issued, Lordship, at page 16.
Page
Page 16, Lordship.
16. Yes,
Also, because one check was dishonored because they have submitted the check after 10th of the month, Lordship. They were supposed to present the check within the 10th. But because of the late submission of the check, Lordship, that one installment was dishonored, but they have collected double the amount on the next month for the month of August. So it is an admitted fact, Lordship, we have paid 12,69,959 in terms of the agreement, or Lordship, whatever Lordship we will say, Lordship, in terms of the settlement arrived by the petitioner and the Eastern PF Commissioner. Now, Lordship, the recovery officer has issued the interim order at page 16. Lordship, we are committed to pay the entire amount, Lordship, in terms of the installment agreement, Lordship. So let us continue to pay, and Lordship may kindly interfere with this interim order, Lordship.
now tell me one thing. Now, yes, what is your stand?
Yes, sir. What my counsel is stating and mentioning the petition, that is totally false, Lordship. Because they have never, as per my was regarding checks, Lordship, not a single payment was done through check. When you are purchasing the entire amount paid by DD, Lordship. I have paid the total instruction, as well as all the checks original, Lordship. Not a single amount was paid, as they are saying, Lordship. Not a single amount through check, Lordship. Entire payment was DD in for DD, Lordship. Not a single payment was done. And that bank attachment was also encouraged by with us, Lordship. This is the,
That is creating us, that is the creating us problem. Lordship. Because
No,
of
so
what
this DD amount,
yes, Lordship.
this is a check. Huh?
No, but
These are checks.
these are checks, not encashment. First one is dishonored, then thereafter.
Okay, they're all dishonored.
Yes, first one dishonored.
First
Thereafter-
one dishonored.
Yes, then when you tell.
Water,
Yes, then when you inform them. they
just
say-
a minute, the
Yes.
first. Dishonored by bank. Not presented to bank due to dishonor of check. All dishonored.
No, see, first one is dishonored.
First one
This is
dishonored.
the first one.
Thereafter, we did not present it.
Oh, you did not present the
Yes,
others
yes.
because
Then when you approach them, they are coming with all three DDs during this 10-year lawsuit.
they're coming with
DD lawsuit.
where?
I've given the official record. Later on 6th lawsuit. And 5 DD we have received during this period lawsuit. From May to November lawsuit. After paying 5 lakhs, then we issued the letter on 9th May lawsuit. That is 19 lawsuit.
Insufficient fund.
Lordship, we have given the bank statement also in our.
Anyway, see, that is, you go and take it up with the bank.
Yeah.
You've
No,
got
Lordship,
case.
only one check was dishonored, the first one.
You file an
Okay.
affidavit? You file a small affidavit
Yes, sir.
and will dispose of the entire matter.
Yes.
Okay. Right.
But they have admitted also that we have paid 12,69,099 in terms. and
Look,
also
one thing we can
only
think
the
of.
first check in.
No, Mr. Kasim, please listen. You pay all your dues.
Lordship,
You pay all your dues at one go. Now, from that, from which month? From
December.
June 23 till February 24. Then we will consider.
No, we have, till December, we have already paid.
No, they're not encashing because of insufficiency of fund.
No, we
You-
have encashed Lordship. This is a false submission, Lordship.
Lordship,
They have encashed.
It is here in front of me. All your checks are here. All these are all your checks.
Lordship, then kindly go through my bank statement, Lordship. I have annexed, and Lordship, I have also the bank statement.
I do not know.
It has been debited, Lordship.
Then you go to civil court. I'm not going to go through your bank statement and see whether you're correct or you're correct. He's saying these are your checks. You're saying that my bank statement says, I do not know. That you go to civil court.
Lordship, on the very first day, Lordship, they have put, they have given one instruction, Lordship, one bank press. That
No,
are also.
Mr. Counsel, these are your checks.
Sir.
It's a plain and simple. And this is a dishonest statement made by the bank. Very clear.
Lordship, this.
And does your statement of account say that none of your checks have been dishonored, all your checks have been honored? Does it say that for this amount on June 2023 it has been paid? Does your statement of account say that? That 1.53 lakhs have been paid?
Yes, Lordship.
It says,
Yes, yes.
then it's wrong.
Lordship,
Then your statement of account is wrong.
Lordship, may kindly see page 29, Lordship, page 29. Three seven 2023, 1,54,000. Then
The
Lordship,
council, this check is for 1,53,993.
yes, Lordship, that amount differs because they have, the bank has charges damages and interest for late payment. For late,
But you see, why should they keep the check with them? They are not the bank.
no, they should.
Whenever
We
a,
have, we have given post-dated check, Lordship, we have revolving bank guarantee and post-dated checks. So they are supposed to present the check before the bank, Lordship. We have given post-dated check. That the statement is also there, Lordship. May kindly-
but this check is dishonored. Let us see, check number 75253. No, this is 75229.
75229.
What about 75229?
The dishonored check, for the dishonored check, we have given the draft. Draft amount, Lordship. For the dishonored check, Lordship, we have given the draft amount. On 8th, Lordship, we have paid 5.
Where-
Thereafter-
Show me the draft. The,
Yes, Lordship.
what is the number?
Yes, Lordship.
Because these checks, nothing is reflected in. You find the affidavit.
Yes,
with-
sir.
with
Page
clear,
20.
with clear evidence. huh?
Page 26, Lordship.
What is this? What is this number? 979,
Lordship.
187.
Lordship.
Now, where is it in the statement of account? And this is dated, no date,
No, they-
no date.
No, Lordship.
Page 26, no date. The
Lordship.
demand draft has no date.
The post-dated checks are of SBI, but this is
Mr.
from
Counsel,
IndusInd
demand,
Bank, from
demand,
from another bank.
please listen. Demand draft is made by whom?
By the,
By whom?
by the petitioner. Lordship.
Who?
By the bank.
By the bank.
By the bank.
Does the bank give a date
no, they did that.
in a demand draft?
Lordship. Lordship.
Okay, there is a date out here, 2606.
Yes, Lordship.
20.
Correct.
Lordship.
Now let us see. In your statement of account, if this demand draft is there or not. 187.
Yes, Lordship. What is it?
Where is it?
Yes, okay, we expect them.
Not there. The statement of account does not mention.
But this bank account is of Lordship, State Bank of India. We have given a draft of IndusInd Bank and they have realized it. They have realized the amount, Lordship. And Lordship,
You have given us the demand draft of Indus Land Bank.
Lordship,
Now, where is the Indus Land Bank statement of account?
that Lordship today I don't have Lordship. But Lordship, on the very first day, Lordship, they have given this instruction. Lordship.
No.
In this instruction, Lordship, they have
Right, Mister?
D-Day,
The letter counsel for the respondents is granted
3 weeks time.
3 weeks time to file affidavit in the position. This is the matter of history. Actually, this is a motion, no?
Lordship, may kindly.
We will issue notice and we'll issue notice and we will issue, right. But Mr.
Lordship, let us pay the
K.
installment,
Das,
Lordship.
learned counsel for the petitioner, who submits that in terms of the last order, it is the first paragraph, last order. Next paragraph, right? The petitioner's counsel submits that the petitioner had paid the monthly installments from May to December 2023 amounting to rupees 12,69,959. However, that's all. Next paragraph, Mr. D. learned counsel for the respondents, on the other hand, submits that the annulment of the installment plan had been made due to the petitioner's check bearing number 075229 dated 10/6/2023 being dishonored due to insufficiency of funds. Next, to the above submission, Mr. S.K. Das submits that the statement of account made by the SBI in respect of the petitioner's account shows that the respondents have been paid the monthly installment every month. He also submits that in respect of the check which has not been honored, demand draft had been made. So, on perusing the writ petition, there is no statement of account showing the payments made in pertaining to the demand draft, combined as much as the demand draft was apparently issued by the Indus Land Bank. Next paragraph. Issue notice returnable in 4 weeks. Mr. S.K. Das, Learned Counsel for the respondent numbers.
Yes, sir, I have responded.
I know, yeah. Acha, Mr. D. Day, Learned Counsel for the respondent.
2, 3, and 4.
2, 3, and 4. Is granted 4 weeks time to file affidavit in opposition. Who is number 1? CGC? Mr. S.K. Roy accept notice on behalf of, huh? SS Roy accept notice of the respondent. This is the matter of the 4 weeks.
Lordship, let us pay the installment also.
Huh?
We want to pay the installment also. Let them accept it. That's lordship. That's much lordship.
That cannot be lordship because already that is cancelled lordship.
After December also, we have
That
paid.
is already-
January, February, we will pay lordship.
Or that is lordship, that is already cancelled by the later lordship. Because they have not paid a single amount for check and it's 3 or 4 DD they have paid to meet up the 12 lakh lordship. So
From a
this cannot
different
be
account.
lordship.
We are not paying anything.
No, look,
in the name of.
12,59,000 lordship, it amount, it comes to,
We have not paid anything, Mr. Counsel.
for demand draft, we have paid lordship.
Demand. Yes, now you said
What-
check. Now
No,
you're
no,
saying
no,
demand draft.
For the dishonor check lordship, we have paid. These are all post-dated checks lordship. We have
Huh?
submitted. These are all post-dated checks we have submitted. And revolving bank guarantee lordship.
When I let him file his affidavit, we'll see.
Lordship, may kindly give observations that we will want to pay lordship. We want to pay.
We'll see. I do
Let
not
them
know.
accept lordship.
Your documents are not in order.
Yes.
You bring the Indus Land Bank
Lordship, we will bring.
statement of account.
We will bring lordship. Lordship, let us, oblige. May I just point out one thing, my Ganesh Singh has given me one section. The demand draft, it does not come in the bank, in the statement of account. Demand draft payment also does not come in the statement of
That's
account.
not fine.
And just now my senior has. advised.
Okay.
That-
Yes, it will not come.
It will not come.
You sure? But when you make it,
Lordship.
where is the other side? He's gone. You see, because he will have to show in his account, then it had to come to him.
Lordship, yes.
What have we said? So 4 weeks now, we said. And this also right. He shall submit, he shall also make, he shall also clarify as to whether the petitioner had submitted demand draft and whether the amounts in the demand draft have been debited into the accounts of the respondents number 2 to 4. What do you, I do not know, you'll be there, I do not know, I'll have to see the facts, let him bring out everything. But you have to pay everything at one go,
We are ready to pay Lordship, as per installment.
huh? Not as
We
per
are-
installment now. All the unpaid areas will have to pay at one go.
We are supposed to get the amount of rupees 20 lakhs. So we may have pay Lordship as a lump sum.
I don't know, let him file his affidavit.
Oblige.
Very please, your lordship.
Yes,
I'll have a look, my lord, last order passed by your lordship. So without making regular settlement, that is all, my lord, allowing one number temporarily by engaging their own employee. And that is total primary violation of the section 105 of the Assam Panchayat Act and rule 4710
My lord, as on date, this writ petition has become infructuous. My lord.
Why?
The department has settled it with the highest bidder,
Oh,
Mushraf.
with who?
Mushraf Ali, yes.
With
Mushraf
who?
Ali.
Mushraf Hussain.
Because Musharraf Hussain, he was earlier surrendered. His settlement was initially cancelled. Then again settlement was initiated.
My lord, initially it was settled with Mr. Musharraf Hussain, but due to ill health, he had
Withdrawn.
withdrawn.
Then,
Subsequently, my lord, the Zilla Parishad passed a resolution that we will run it on our own. So the Zilla Parishad was running it. In the meantime, Musharraf Hussain once again requested that my health, I've recovered from my ailment. Now I'm ready to run the market from here on. So they passed a new resolution.
when was the resolution passed?
This new settlement order was passed on 1st of February 24, ma'am.
1st of February
1st of February
20.
24.
Prior to the order of this court.
Two.
Huh?
Two.
1st of February.
1st February, the order passed by this court is on 2-2,
Yes.
So a day before.
day before.
No. Once cancelled, once his settlement cancelled, he of his own made an application expressing that.
Whatever it may be, at the end of the day, won't you have to challenge that?
No, that we have not challenged.
So now he should challenge the private party.
Now you've got to challenge that.
Yes, ma'am.
Right. Heard Mr. Then, you just write the last order,
Because
first
it is,
paragraph.
because
Ah.
there are some certain condition that comes in the notice. Once it is withdrawn, this is security money will be forfeited.
Correct.
It is in the minor tender to condition, terms and condition written itself.
Clause 10.
Yes, no, the clause 6, 7 is
Clause-
there, and clause 26 is there.
Anyway, so now what to do?
Yes, no, that I will challenge, ma'am.
Right, Mr.
P. Handick, my lord.
P. Handik, Learned Counsel for the respondents number 1 to 4,
1 to 4, my lord.
submits that. The highest bidder, Mr.
Mushraf Hussain.
Mushraf Hussain, has been awarded, has been awarded the tender
Tender.
and has been awarded the tender by meeting minutes dated 1/2/2024,
2024.
made by the Zilla Parishad,
Zilla Parishad settlement order.
by the Zilla Parishad. The settlement order is dated, what? What is the,
My lord, the new settlement order is dated 1/2/24.
okay. And settlement order has been issued accordingly. First off, he submits that the highest bidder had initially withdrawn his bid on the ground that he was unwell. First off,
Or medical ground, ma'am.
unwell. The Zilla Parishad thereafter ran the market on their own. First off, however, on a request made by the highest bidder that he had recovered from his illness and wanted to run the market, the same was accepted by the Zilla Parishad. Next part. India, the submission made by Mr. P. Handik, the writ petition is closed as instructed.
Yes. Good.
22.
Petition. NIT is on page 28. The petitioner submitted a tender paper being, after that, he was selected for a technical bid and with other bidders, but he was not informed when the opening, when the financial bid was opened.
Huh?
The response number 5, there is a specific allegation response number 5 that he has manipulated to accommodate the response number 6.
Who has manipulated?
Response number 5.
Has manipulated. How has he manipulated? How has he manipulated the financial bid?
By lowering the rate of the response number 6.
How do you say that?
The petitioner came to know, but because
Petitioner came to know how? Spy camera or something?
from the office of the response number 4.
Any document, anything?
Because I have annexed my Alexa at my page on 3224,
Page
page 37.
37. Yes,
MS Open Informatics has qualified the technical bid of the tender participation. Was clearly seen in the date of opening of technical bid on 25/1/24. But your kind of did not issue any notice to intimate the bidders regarding the opening of the financial bid, filing the provision of Assam Public Procurement Act, so and so.
this is your letter.
It's my letter.
Then what was the rate? What was the rate initially given by the respondent number 6?
As per my from the office, I am the lowest bidder. I have given 10% of the estimate price. 10% of estimate price, because in the finance bid, I have to the respondents have to give a notice of information that today it will be
Mr.
open.
Counsel, the problem is your case is all on speculation. There's nothing to show. You're just basically saying that you have come to know. You have come to know how has his bid been lowered, the respondent number 6? What was his initial bid? It has been lowered to how? We cannot have a roving inquiry without you giving some instance of how there has been a forgery or something, fabrication
Because
of documents, huh?
as per my information, it was lower to 10%, equal to the petitioner. I stated in my representation. And moreover, when a financial bid was opened, we are not informed that the date and time of the place where the financial was opened is mandatory as per the CBC guidelines.
We can issue notice, but nothing much will happen. I think. You have got to come up with some better story. Knowing that I've come to know. You have come to know, so what? Come to know, only you know it, that's the problem. You have got to show the court
Yes, so
that you've got to show the court that it has happened. How will you show the court?
because
You think that they are going to say that yes, we have done illegality?
Lordship, see, one thing, on second we can be know, on third we have given the letter to the executive officer.
And what did they say? Yes, you're correct.
No, they have not given any reply.
So so let them give a reply.
Because the work is of 30 days. In the meantime, they will complete the work because
No stay, Mr. Counsel. No stay. It's just or not. You have come to know, so what? You have come to know many things, so what? We do not know.
your lordship.
It has to be proved. You have got to give.
Appreciate one thing, because they have not informed about when the financial bid was to be opened.
I don't know. We cannot condemn anyone unheard.
When financial will be open, that is reflected in the
No,
tender
it's
itself,
it's about technical bid, not financial bid.
The tender will be received up to 1 PM 25/1/24 and will be open at 1:30
Yes.
PM on the same day
This is
at the
about,
office of the Amgul Municipal Board.
this is about,
That is-
this
it's
is about
reflected
technical
in
bid,
the
not financial bid.
tender notice.
It is two bidding process. First is technical bid to be open. After technical bid is open, is financial bid. Your lordship may see
Let us see the NIT.
page 28. Sealed tenders are embedded into bid system, technical bid and price bid in separate envelope. In the prescribed format with a validity period of 180 days of affixing code system of this 8 to 5 only. From the valid registered contractors, firms, eligible category mentioned for the following works under the head of stream awards of it abstinated. Detail may be seen at the office or undersigned for the date of 1/18/2024 to 21/24 between the office hours. The tender will be received at 1:25/1/24 and will open at 1:00 PM on the same day at the office of Amguri Municipal Board in presence of intending.
So,
tenders.
Mr. Counsel, according to you, when was the financial bid open?
It was open on second.
One second.
Your lordship, page 30, surplus 3. Page 30, surplus 3.
Second of which date? 2nd of February? It was open on February 2nd.
Page 30 plus 3, technical bid and financial
Page
bid.
38.
There's two bid. The technical bid and financial bid have to be submitted, and financial bid have to be submitted in separate in two envelopes. These two envelopes shall be put inside one outer
Where are
envelope.
you reading? Where are you reading? Page 38.
Page 30, page 30.
30. 330, yes.
The technical bit and financial bit have to be submitted and financial bit have to be submitted in separate in two envelope. These two envelopes shall be put inside one outer envelope addressing to the undersigned and mentioning the name of the work for which bid is submitted. It's two bidding system.
So,
First technical bid is to open. After we have qualified the technical bid, we have to inform that we will open the financial bid.
no, it can be opened on the same day also. Why?
It was not open. We are present the whole day. On 25th, it was not open. Only the technical bid was open. So
So you just find out, but when, can you bring the records?
Well, actually, it's a municipal board, my lord. Amguri municipal board.
it is
Oh, municipal.
it's only about 30 days. In the meantime, it will be completed.
No stay, no.
This is the one circular that when the bid is open, all the bidders should be present. CBC circular.
Where is your representation to them?
Page 37.
37. What is this for? Is it supply or what? Supply of?
Construction of RCC slab. RCC slab.
Okay, over the drain.
About it. The time period is 30 days.
So he says it was opened on 2nd February.
At least his statement ballot so far, as far.
So why
the
should we
other
dis-
tender
so we
ballot,
should-
it
huh?
will be open in the same day, man.
No, but then he has taken a stand. Why should he tell a lie? If he is found to be telling a lie, can always be, we can always correct it. Anyway, right.
It will be reflected from the my lord after only.
Huh?
We speak of
Yes.
inspection or that can be my lord service.
Right. Heard, Mr.
SR Gogoi.
S.I. Gogoi, learned counsel for the petitioner, who submits that pursuant to an NIT dated 12/1/2024 for construction of which one? Page 28, which one?
Seal number 4.
Construction of RCC slab over the existing drain at ward number 7 and 9 of Amguri town at an estimated cost of rupees 4 lakhs, comma. The petitioner submitted his tender. Full stop. In terms of the NIT, comma, the tender was to be done was by way of a 2-bid system, and the bids were to be opened and the tenders were to be opened on 25/1/24 at 1:30 p.m. Next one. The petitioner's counsel submits that on 25/1/24 the technical bid of the petitioner was open and he qualified the technical bid stage. Full stop. He submits that no notice was issued to the petitioner or other bidders as to when the financial bid would be opened. And as such, the petitioner was not informed of the fact that the financial bid would be opened on 2/2/2024. Full stop. He submits that as per what? He submits that he came to know that the financial bid had been opened, financial bid of the respondent number
Respondent number 5.
5 had been opened in the absence of the petitioner and other bidders. And his bid was made lower than the petitioner. Illegally. First up. Thereafter, the work order dated 8/2/2022 was issued to the petition. Today is what date?
Today is Monday.
Come to page 39. What is this?
8/2/22, my lord.
8/2/22. Oh, it is 8/2/22.
Work order.
Okay. Where is the work order?
Work order is, work order, I have not furnished to us. Because it was not published,
It was issued to,
issued to respond number 6.
okay, whatever I said. Thereafter a work order was issued to the respondent number 5.
6.
Six.
But this work, my lord, probably this is from another work, my lord.
This is experience certificate. Page 40 is the experience.
What work order, my lord?
Huh?
Page 40 is the experience certificate of the.
Page?
40 is the
40.
experience certificate of the petitioner. I've given an experience of the PW works. This is annex page 40.
No, this is.
Page 39 is from related to some other work, my lord.
Huh?
Page 39, my lord.
Huh?
Need is page 28. Page 28.
Order relating improvement
Page
of-
39 is different. He just wants to show that he has got experience.
Yes.
That's all. He also submits that the work is to be completed within a period of 30 days. Oh, sorry. What to do? We don't know what you're saying is true or correct.
Not to start the progression of work.
Huh?
To state the operation of the.
Why? Can you give, what we'll do is we'll issue notice. You give dusty service.
Yes.
We will,
That
we,
is 30 days, it will be completed in one week.
you give dusty service by tomorrow. We'll take it up on Tuesday.
Yes, or in the meantime.
No. 30, he will not to finish that work.
Because
No stay.
it is only 30 days.
We are
work.
Mr. Council.
Work. Lordship will be infectious.
No, Mr. Council.
As is the 4 lakhs, in a day or two, they will complete.
In a day or two, they'll complete, then they've already completed them.
No, yeah, because it is not, as per my information, that I have bring, it is not started. It is not started.
It has not started.
Yes, sir.
So
Okay.
today,
Lordship means for a week, Lordship, for a week, I will do the same for a week.
once you can stay, will be problem.
For a week, you also,
No, sorry.
for a week, Lordship may vacate it. Vacate it if there is, I'm saying like, you know, vacate it for a week. Only
You see, we are giving you chance to, we'll issue notice, you take
because
steps.
they are saying Amguri, the petitioner will come to Guwahati, then again, it will take time, that's for a week.
This is a
Lordship for a week,
issue notice returnable in 5 days. Mr. M. Chetia accepts notice on behalf of
1 to 3, my lord.
1 to 3. Petitioner takes steps for service of notice upon the respondents number 4, 5, and 6 by registered post with AD within the course of the day. In addition to the above, he shall serve notice upon the respondents number 4, 5, and 6 through dusty service and file affidavit of service by 12 to 24. List the matter on 13 to.
in the meantime, the Lordship.
No, not on this kind of.
Wow,
We do not know. How do we, you have not shown anything, nothing prima facie in your favor.
Right.
Apology for the noise.
This is Let us read this. Yes, what is this
My lord,
matter?
subject matter of the case pertains to, the petitioner, my lord, is the T state.
Ah.
And the subject matter of the case pertains to recovery of arrears of provident fund. Now, my lord, there are two facets of this case. The first facet is purely factual. The other facet is purely legal.
Recovery of arrears.
Recovery of arrears of provident fund. Now, my lord, there are two facets of this case. One is purely legal, other one is purely factual. So far as purely factual part is concerned, the factual part is there is a dispute regarding the arrears. Petitioner says we have paid everything. They say nothing doing. Around 80 lakhs something is still due. So, my lord, the dispute is that exactly what amount is due. So, for that very purpose, they have filed an interlocutory application praying that a retired High Court judge be appointed to calculate and to find out what exactly is the amount due. That's the factual part. But the legal part, my lord, here is, if at all something is due and arrears are to be recovered, what law is to be followed? Now, in this case, my lord, what happened was, initially, the Bakijai proceedings were initiated under the provisions of the West Bengal Public Demand Recovery Act of 1930.
Against you.
Yes. Now, my lord, some of the Bakijai proceedings were closed after we made the payment and settlement was made. In case
So how
of,
many Bakijai proceedings are there?
there
against
were plenty, my lord. Once I go enter into the case, my lord, I'll place everything.
Oh.
I have got the,
So there are some are still pending.
so my lord, let me complete. So my lord, some of the Bakijai proceedings were closed. Settlement made and we made the payment. In case of some other Bakijai proceedings, this honorable court quashed the proceedings on the ground of violation of section 10 of the Bengal Public Demand Recovery Act of 1930. Section 10 provides for opportunity of hearing. Opportunity of hearing was not provided. That was the ground. Section 10 violated. Bakijai proceedings were quashed and the honorable court gave them liberty to initiate fresh proceedings in accordance with law. The expression used was in accordance with law. That was in 2013. Now, my lord, after 2013, there is another act, namely, in short, I'll call it Assam Tea Plantation Provident Fund Scheme Act of 1955. There is an act. Now, in this very particular act, the section 15 of the act says, of the 1955 act, that the arrears of Provident Fund, etc., can be recovered just like that of land revenue. So, prior to the amendment in 2016, the section 15 as it stood in the pre-amendment days, it only provided for recovery of Provident Fund arrears as land revenue. For that, my lord, they used to take recourse to Bengal Public Demand Recovery Act of 1930. In 2016, that is 3 years after the judgment of this honorable court, section 15 was amended. There was no substantive change in section 15 as such, but the subsequent portions were very interesting. In section 15 capital A to capital G were added by the 2016 amendment. And you know, these provisions were very, very punitive, very, very stringent. For the first time, these provisions were introduced, and these provisions did not provide for any opportunity of hearing also. Now, so what happened was, after these 2016 amendment, straight away, those Bakijai proceedings which were caused by this honorable court, and possibly some other pending Bakijai proceedings under Bengal Public Demand Recovery Act of 1930, they brought all that under the 1955 Act as amended in 2016. And they issued recovery notice to us under section 15 of the 55 Act as amended in 2016. This recovery notice will not be never received. That is our case in the presented petition. Once the order of attachment was issued,
you have not received the recovery
that
notice.
was our case in the presented petition.
So that can be cured anytime.
So, my lord, what happened was, according to us, we never received it. When they passed an order of attachment under section 15, capital B, we came before the honorable court assailing the legality of the order of attachment itself. Then the proceedings were initiated before the Honorable Court. In the meantime, certain orders were also passed by the Honorable Court that since this amount you admit, you pay this amount, that amount will also be paid. So substantive amount was also paid pursuant to the order of this Honorable Court. On one particular occasion, substantively the matter was heard before my Lord Justice Goswami. Justice A.K. Goswami, as his lordship then was. There is a very elaborate order. So the fundamental question of law which I had raised as to whether the pending Bakizai proceedings, which were there under the Bengal Public Demand Recovery Act of 1930, whether those Bakizai proceedings, those cases could be brought here under the 2016 amendment of 1955 Act, and this process could be initiated. And the ground was, therefore, the order of attachment under section 15, capital B, as well as the recovery
Would
notice
not be applicable.
cannot. You
That's
can't take recourse to this very particular law. So this question of law was also framed. So, my lord, this is what it is all about. And this is the stage of the case. We are ready with hearing. Substantive issues are involved. My lord, I can go deep into it as my lord pleases. Because so far as my lord, the interlocutory application is concerned, that is for appointment of a retired High Court judge. My lord, that is beside the point, because first of all, the issue is how do you make a recovery? If my lord, it is Bengal Public Demand Recovery Act of 1913, there we get opportunity of hearing. We give a reply. And if there is a dispute regarding the amount, the adjudicating authority over there having the power of a civil court can, my lord, take appropriate steps for that purpose, for making the calculation by appointing a commissioner. So, my lord, that would be the basic issue. That is my submission.
So that is your issue in the writ petition.
Yes, madam.
And it was not decided.
The issue has been framed
Oh.
by Justice Goswami, but yet to be answered.
Yeah. So basically, his case is that the first issue has to be considered. And then only the question of that arbitration will come into play. Because one is the question of law. The question of law will first have to be decided. And then the question of how much is to be paid. So, we'll have to see whether he's saying that either the 1913 Act or the 1955 Act, which one would apply to the facts of the case?
Yes, Lord. That's the law regarding what procedure for recovery.
Correct.
Lordship, there cannot be a dispute that what is it that we are trying to protect? What is it that has been, what the attachment order was for what? It was for recovery of what is Provident Fund.
What was?
Provident Fund. Provident Fund. What is Provident Fund? Provident Fund is part of the salary. You're supposed to pay salary every month. 12% of that salary under this act or even before. Provident Fund is a part of a salary you give the wage earners, the workers. So instead of giving 100 rupees salary, you cut 12% of that, what is due to them, and entrust it to us. So every month you're supposed to do it. And there's comprehensive provision about it. How you do it, who's supposed to do it. At the end of it, it is them who has to do it. They fill a form. They have to then tell us how many number of workers are there, what is the amount, and they're supposed to do it every month. It is them. We have nothing, no role in that. Our role is that at the end, the money must come to us because we are custodians. So both of us are custodians and entrusted to us monies that don't belong to us. That is the bottom line.
Okay, so you all are ready?
Absolutely ready, yes. Because the due is from 1977, so.
How long will it take?
Minimum 1 hour, but it will go up to 2 hours. It may go up to 2 hours.
May I just complete?
Yes.
Recovery comes after quantification of amount, which is
Correct.
which is why we.
No, that is one aspect.
So
Now, quantification of amount.
which is what prompted us to file the IA. At the end of it, whatever the method of recovery, amount has to be decided. There is a problem with amount. And Lordship, which is why we filed an IA. Lordship, in fact, if I can show you, this Honorable Court tried to reconcile. There were a lot of meetings. It didn't happen. Which is why we said, okay, fine, let's go to, under 226, Lordship, I can't expect you to look at challans and say, have you paid her? And it's all their documents. We have no role in it. The amount of recovery that we have determined is on the basis of a form that they filed. and they are required to file. So we have no role.
So basically,
Question of law is relevant.
no, wait,
It is relevant,
the issue is basically non-payment of the provident fund by
The
the
workers.
company to you. So,
Which I have to pay the workers.
which you have to pay the workers after they retire.
Yes, Your Lordship.
Now, because he didn't pay, you issued notice and then you have started the Bakijai proceedings.
No, Lordship, Bakijai was always there.
Always there.
Bakijai was there under the Bengal Act, what he's saying.
Yes.
In 2015, this act, the liability is of 1955. The
Ah,
liability
yes.
to deduct and the
It
consequences
is as per
of
the
deduct-
1955 Act.
1955. Instead of as an area of van revenue,
So
we changed it to areas
the
of-
manner in recovery is
exactly, Your
made
Lordship.
different.
And Lordship, it is settled law. Procedural is retrospective. It's for efficient collection. The charge remains the same. There is no change in the charge. So the liability, he cannot dispute the liability to pay.
Liability to pay is there.
Exactly.
Only
Your
the
Lordship. And
manner in which.
So- Exactly, Your Lordship. So how do I am relying entirely on his documents, which is why in the meetings we told him, please bring your documents. You're saying you paid XYZ to Bakijai. Please credit it. We don't want to take more money than what is due to us. It's for the workers. It's not my money. I am a custodian. I have to give them. And we've given. It's a fungible, our fund is fungible. So we get from somebody else and we give them. So he's a chronic defaulter since 1977, but people have retired since then.
Now,
So we have paid. So which is why there was an urgency and we moved this court. Please hear us, because at the end of it, we are a fund which is fungible. We get from, and this is the problem with tea plantation. Sapre committee was constituted before. So in line of Sapre, we said, at least come on, let's determine the amount. That is a pressing need. And it is their amount. They have to give us, I'll show you, Your Lordship, when my turn comes. It's a form they fill. So we have, in fact, after this, withdrawn all Bakijai. And we've given up computation. We are saying that Bakijai has not given us this much is what we got, and we'll credit. So all they have to do, till date, we have not found a challan. All they have to do is come to us and say, this is the amount that I have collected. This is the amount I've already deposited against it. And whatever is balance, you give. That simple determination has taken us 2018 to 2023, 5 years. And in the process, the workers.
so first of all is the quantum payable.
Yes, Your Lordship.
That has to be decided by the arbitrator according to you, or what?
Because there is no determination. We've not been able to reconcile. Your Lordship, I'll show you orders when my turn comes. We've not been able to reconcile. The High Court directed twice over, we met, nothing happened, which is why we prompted. There was not, reconciliation was not possible because he didn't come, he came to us without any papers, etc. We brought, it's all there, part of an order of this court. And then prompted us that at least find somebody else. Why take Your Lordship's time to reconcile chalans? And until supposing he wins and says it's Bakijai. Even Bakijai, what is the amount you have to tell us? We have to know what the amount is, which is why, Your Lordship, we made a prayer. And in fact, on the last occasion, liberty was given to me that you can press. If it doesn't go on and it takes time, press for that. At least pending this hearing, let there be, when you have to apply whichever act, at least let the amount be known and reconciled.
Okay, so you want the amount to be
Yes, Your Lordship.
clarified.
Which is our IA, Your Lordship.
Because he has to pay anyway, whether it's this way or that way.
I can satisfy you on that.
On what?
On the fact that the liability is 1959 and it is his. So he can't say
1955.
something like this act that you have to deduct what is the liability. 100 rupees is a salary, supposing I take 12% of that. That means supposing I'm the worker, he doesn't give me 100 rupees, he gives me 88. The 12 rupees he puts in my fund deposit, and then equivalent amount he also has to deposit. That's provident fund that the employer also has to give. So 24 rupees every month at the end of the month, he has to deposit with us in a form. That is all. That liability, nobody can contest. And it's not contested.
So that amount has not been deposited.
Yes, Your Lord. Since 1977 is our contention. And he has not been able to, in the course of last 5 years, show us that there is a situation like this, which is why we said, okay, forget us. You show a third party.
Okay, that is regarding the amount.
Liability.
The amount that has to be paid.
Which is why we amended the law because Bakijai Lordship was taking too long. At the end of it, there were orders which said give 4,000, 40 lakhs, they're saying give 4,000 every month. It was unworkable, not in the interest of the workers, which is why law permits us Machinery provision.
So,
retrospective
the Bakijai method of recovery
as land revenue, land area revenue.
as land revenue. So this was amended when?
2016.
By way of amendment of section 15.
Yes, Your Lordship.
That is 55 Act, not 1913 Act. 1913 Act, there is no amendment below.
1955 Act amended in 2016, amending section 15
Yes.
by addition of A to G. You said.
A to G.
A to G.
But Bengal Public Demand Recovery Act, there is no amendment.
Lordship, we must not confuse. Section 15 was under this act.
Under which
of
act?
1955.
Ah.
Lydia. 1955, section 15, mode of recovery of money due from employer. That was in 1955 onwards. That had replaced everything else, including Bengal. Okay, it says any amount due will be recovered as area of land revenue. Lordship, page 10.
Well, then I should make my submission.
Just a minute.
That's a very partisan narrative.
Yeah.
Sorry. Lordship, page 10. This is the act. It's a 55 act.
Yes.
Page 10.
Yes.
Section 15.
Yes.
Mode of recovery of money due from the employer.
Yes.
Any amount due from the employer in relation to a plantation to which the act of the scheme applies in respect of contribution made to PF fund under so and so, last line, to be recovered by the government or person authorized by it in the same manner as an area of land revenue.
So how
This
do you
got amended.
how do you use this 15? How do you apply it?
Since 55 this has been applied.
But how? Is it-
Lordship, and the
Acha, straight
Bakijai
away
DC
to the
office.
to the Baki, in
Yes,
the
yes, yes,
Bakijai.
The DC office in Bakijai.
Bakijai
Yes,
certificate.
Yes, Your Lordship.
Okay.
So so we issue a recovery notice to the
DC
DC, and the DC then as a land revenue area recovers it. in
recovers
that
it from
DC.
the
Yes, Your Lordship.
by attaching his property and selling it, or
Not
Bengal
then,
Public
not
Demand Recovery Act.
huh?
Under Bengal Public Demand Recovery Act.
This got amended, Your Lordship may see it right at the end. Unfortunately, there is no pagination. It'll be marked, Your Lordship. 2016.
What?
This particular section 15 got amended.
Yes.
Lordship, there's a flag of 2016.
Yes.
Yes, that is the amended.
2016.
Yes,
amendment.
received assent on 2nd March 2016.
Yes.
And Lordship may see it's page 241, section 15.
Yes.
And it says, clause 3 actually, in the amended act, section 15 of the existing provision, the following shall be substituted. And 15 comes in. Internal 241. Any amount due from an employee in relation to plantation to which any scheme or
15 B to G.
Yes, Your Lordship. And then we've gone to 15B
Yes.
below.
Yes.
15B. So where an amount is an area under section 15, the authorized officer is to issue to the recovery certificate, a certificate under a signature specifying the amount of areas, and recovery officer on receipt of such certificate shall proceed to recover the amount specified therein from the plantation, or as the case may be, the employer by any one or more of the modes mentioned below. First is attachment. Attachment and sale of movable, immovable property of the plantation, or as the case may be of the employer. So it extends it. If it's not enough for plantation, then it goes for employer, arrest and appointing. We've only gone A, and that has been stayed. So he's got his plantation back. He's not running it. Bogitala, he's not running.
Who is the recovery officer?
Lordship is defined. Page 240, if you turn ahead, it's section 2
Yes.
L. Recovery officer means any officer of the Board of Trustees who may be authorized by the state government by notification, so and so to act.
My lord, it is not applicable. That is going to be my submission.
No,
I'll
no.
make my submission.
I'm
No,
just
but it is
showing you, Lordship, this is what we have applied. Mode of recovery.
And that is
But
not
my primary submission is quantification.
Ah.
And it is entirely died. Lordship, may I take you through? Or
No, just one thing. Now, so your case is basically that the 2015 amendment,
Has been
two
applied,
thousand sixteen amendment
yes, has been applied for recovery.
would have to be applied.
Yes, yeah.
And it can be applied retrospective.
Yes, your lordship.
Some citations on that.
Plenty, okay, lordship. May I?
Yes,
What one?
then we can hear it.
Okay. What one, dear? 66, dear. Read Akiba. Next to 94, dear. Yeah. Lordship has 1966 Supreme Court,
Yes.
1206.
Yes,
It's actually a 5-judge bench, your lordship. Yes.
those times they were all five.
Right, yes, your lordship, yes. Paragraph 4.
Yes,
Page number.
Sorry, copy 9 is here. Actually, your copy.
1206.
1206. Union of India versus Sukumar Pine. Lordship, paragraph 4. Mr. J held
Yes,
section 23 violated 14 of the constitution and accordingly ultra violates the constitution and the relative
section 23 of what?
lordship. It's actually not relevant. It's foreign exchange. FERA.
Okay,
FERA. Held what lordship, the second line actually is important.
yes,
Accordingly ultra violates the constitution and the relative provision of so and so. Now, regarding the second point, namely section 23(1)(a), having been substituted by the amending act of 57, would have retrospective operation in respect of alleged offences which took place in 1954. The High Court came to the conclusion that the petitioner has a vested right to be tried by the ordinary court of the land in which the rights of appeal were all open to all. And although section 23(1)(a) was procedural, where a vested right was affected prima facie, it was not a question of procedure. Therefore, the High Court came to the conclusion that the provision as to adjudication by the director of the enforcement could not have any retrospective operation. This was the thing. What's your paragraph 6 now? The learned Solicitor General appeared on behalf of the appellant, contended the High Court was in error in holding that the accused has a vested right to be tried by an ordinary criminal court. He says that the amendment only changed the venue of trial from magistrate to director of enforcement in some cases, and no vested right was affected. He refers to decision so and so as follows, and this quote is important. In this context, it is necessary to notice that what is prohibited under section 20 is only conviction and sentence under ex post facto law and not trial thereof. Such trial under a different procedure from what obtained at the time of commission of the offense or by court different from that which is competent to try at the time cannot ipso facto be held to be unconstitutional. What is important is what follows. A person accused of a commission of an offense has no fundamental right to a trial by a particular court or a particular procedure, except insofar as a constitutional objection by way of discrimination or violation of any other fundamental right may be involved. Then did they talk about the amendment and what the differences are? What's your paragraph 8?
yes,
Effect of these provision is that after the amendment of 1957, adjudication proceedings or criminal proceedings could be taken up in respect of a contravention of section 23, while before the amendment, only criminal proceedings could have been instituted. So there was a change in procedure. It could be either adjudication of criminal, before it was only criminal. The High Court has already held that the new amendment did not apply to contraventions which took place before the act came into force. Mr. Chatterjee, learned counsel for the respondent, urges that substantive vested rights to be tried by ordinary court existed before the amendment, and he relied on Maxwell so-and-so, which stated the general principle, however, seems to be that alterations in procedure are retrospective unless there are some good reasons against it. He says there is good reason if the principles of Article 20 are borne in mind. In our opinion, there is force in the contention of the learned Solicitor General. As observed by this court in so-and-so, a person accused of the commission of an offense has no vested right to be tried by a particular court or a particular procedure, except insofar as there is any constitutional objection by way of discrimination or violation of any other fundamental right is involved. It is well recognized that a person has a vested right, sorry, Your Lordship, it is well recognized that no person has a vested right in any procedure. And we see no reason why this ordinary rule should not prevail in this case. So this is the ordinary rule. And Lordship, when it goes on, there is no principle underlying 20 because it was a criminal FERA case 20, which makes a right to any course of procedure vested right. Mr. Chatterjee complains that there is no indication in the amending act that a new procedure would be retrospective. And he further says it affects the right of appeal under the CRPC. But if this is the matter of procedure, this is important, Your Lordship. But if this is a matter of procedure, then it is not necessary that there should be a special provision to indicate that the new procedural law is retrospective. Lordship, this is the first, and it's a follow-up of Maxwell. Basically says, no person has a vested right in any course of procedure. 94. Copy 9. Lordship, paragraph 10. This is more recent, sorry, 1994, 6 SCC 623.
Yes.
Paragraph 10. The basis, Lordship has paragraph 10.
Yes.
The basis of distinction between statutes affecting rights and those affecting merely procedure is well recognized. Maxwell, Murphy, drawing the lines of Justice Mellish in so and so, no suitor has any vested interest in a course of procedure, nor any right to complain if during the litigation the procedure is changed, provided of course no injustice is done. It is true that if one traces any substantive right back far enough, it'll be found secreted in the intricacies of procedure. Then it cites Cockerline. The liability is imposed by the charging section so and so. The subsequent provisions as to assessment and so on are machinery only. They enable liability to be quantified and when quantified to be enforced against the subject. But the liability is definitely and finally created by the charging section and all the materials for ascertaining it are available immediately. I continue, Lordship?
Yes.
Then they cite Halsbury. It is important to distinguish between charging sect provisions, which impose the charge to tax, and machinery provisions, would provide the machinery for quantification of the charge and levying and collection of the tax in respect of charge so imposed. Machinery provision do not impose a charge or extend or restrict a charge, elsewhere clearly imposed. Then Blacks. As a general rule, law which fixes duties, establishes rights, responsibilities among and for people, natural or otherwise, are substantive in character, while those which merely prescribe the manner in which such rights and responsibility be exercised and enforced in a court are procedural laws. Then it goes on to Salmon. Pretty much the same thing, Your Lordship. The law of procedure may be defined as that branch of law which governs the process of litigation. It is the law of action. Just quote actions paired put. Using the term action in a wide sense to include all legal proceedings. All the residue is substantive. Substantive and relates not to process of litigation, but to the purpose and subject matter. Substantive law is concerned with the ends which the administrative justice seeks. Procedural law deals with the means and instrument by which those ends are attained. The latter regulates the conduct and relationship of court and litigants in respect of litigation itself, and the former determines their conduct. What facts constitute wrong is determined by substantive law, and what facts constitute proof of wrong is a question of procedure. So far as the administration of justice is concerned, that application of remedies to violated rights, we may say that the substantive law defines the remedy and the right. while the law of procedure defines the modes and conditions of the applications of the one to the other. Lordship, then it goes on. So it's the next case. The division law into two broad categories of substantive law and provision law, procedural law is well known, broadly stated, whereas substantive law defines and provides the rights, duties, and liabilities. It is the function of the procedural law to deal with the application of the substantive law to particular cases, and it goes without saying the law of evidence is a part of law of procedure. Then it goes on, your lordship, and then 18. Here's the final determination. Lordship has 18.
Yes.
Procedural law, generally speaking, is applicable to pending cases. No suitor can be said to have a vested right in procedure. It must, however, be noted that a provision can be partly substantive, partly procedural.
So you are saying basically that the 2016 amendment is a procedural law
Yes, your lordship.
for the collection of the provident fund
Yeah.
from.
I don't think they're
So-
disputing that they're liability. They've taken 12% of the wages.
No, I don't think they're disputing on
Yes,
that. They're only
yes.
disputing on the, I think, maybe
How to recover it?
how to recover it
Yeah,
is one, and
yeah,
of
yeah.
course, maybe, I don't know, the quantity, I don't know, it might be on the quantity also.
Yes, yes.
But that's all.
Lordship, there are other cases, but
Other cases?
on procedural and substantive, you want to see. Like,
How many? Don't read out the entire case law.
Lordship,
Just tell
this
me
is
a sec.
everything. Lordship, just to say, Arbitration Act, your lordship. Section
Just,
34.
no, just give
automatic
me
stay.
your other case on the procedural and substantive law.
Lo-
Any other use?
Yes, your lordship may take 2018, 6 SCC, 287,
2018,
6 SCC,
6 FCC,
287. Okay, please.
287.
2018, 6 SCC, 287, Kochi Cricket.
Para,
Para 65 and 67.
and any other? How many have you got? Don't give me too much.
Lordship, same, it's
Okay. So that's enough, I think, on the procedural and,
on procedure, yes, sir.
and now, that's all. And what are the other cases you're talking about?
Lordship, nothing else. On law, it is whether retrospective or procedural, that is. it.
That's all.
Other
That's,
facts, we can establish.
facts is a, facts are a fact. So that's the, if there's a
liability,
dispute.
yeah.
If there's a dispute on the quantum.
Yes.
Then we'll have to see how to go about it.
No, Lordship, if you want to see what is this amount really, which is why the pressing urgency and the injustice.
Okay. Amount, you mean now, on the amount.
The charge.
Okay,
Section-
where is that?
Section, Lordship has a black
Yes.
Assam Act.
No, where is it? In the writ petition, which is the impugned order?
Oh, that's the attachment order, your lordship. Lordship, then maybe,
Page,
lordship, the attachment order is at page 23.
order page 20. Okay.
23.
Yes, then the amount?
The amount is 88 lakhs. Lordship, I was more on what determines the amount under the act.
Okay, yes.
This is to recover what
Yes,
due,
yes.
what due. Lordship, that is, if you take the act,
Section,
Lordship, first is section 2A, contribution. It means deduction from the wage. So these are amounts that they have earned, your lordship. Which is why recovery efficient is important. And which is why procedure can be retrospective.
yes,
Deduction of wage. Lordship has page 2, right?
yes, yes.
2A, contribution means deduction from the wage of an employee for deposit to the provident fund or insurance funds, and the amount payable by the employer in respect of each employee.
Yes,
Lordship, I will not trouble you with other things. Straight away, section 3.
yes.
The state government by notification shall frame a scheme to be called the Assam Tea Plantation Provident Fund Scheme for establishment of the Provident Fund for the employees. 3.3, your lordship. I showed you, lordship, the contribution deducted from the wage. The contribution which shall be paid by the employer to the Provident Fund shall be 12% of the total wages, including all such allowance as are to be included in the wages. Under section 2H, for the time being payable to each, and so it is contribution is 12% paid by the employer, which is deducted from the wage, and the employer's contribution shall be equal to the contribution payable by the employee in respect of this. So you deduct 12% of the wage, and the employer puts in equal amount, and that's the contribution. Lordship, section 6 is, this is sacrosanct, so it's against attachment. If they went bankrupt, they can't attach this. We have the first right. Section 10 says that. Lordship, now section 11.
Just a minute, section 6.
Section 6 is protection against attachment. I'm gonna
Yes.
not trouble you.
Okay.
Basically, this amount, the contribution amount is sacrosanct, cannot be attached in any proceedings, cannot be assigned or charged, and shall not be liable under any decree or order of any court in respect of any liability or debt incurred by the member who basically is the employee, is defined 2E. Neither A. So it is sacrosanct. Similarly, section 10.
Yes.
If he went bankrupt, we have a first charge. Again, in line that it's not his money nor my money. It's something that somebody has worked for and has given you as his savings.
Yes.
Now, 11 is important, Your Lordship.
Yes.
Section 11, responsibility for collection of contribution. Every employer shall be responsible for collection of contribution, their remittance in accordance with the provision of the scheme, and maintenance of necessary records in respect of members of his tea plantation or tea factory, and shall bear the cost thereof. Section 11A, if the employer fails to deposit employer's contribution together with the employee's share of contribution within 30 days of its collection, the employer shall be liable to pay interest at the rate of 15% per annum on the area till it is deposited. Lordship, our problem, and this, which is why we actually moved the IA. We don't even know the amount. So there's no question of a charge of interest.
Why don't you know the amount?
Because it's disputed, Your Lordship. Principal amount has to be determined. We know, but there's a dispute and there's attachment has been stayed.
No, but then you can calculate on the number of employees
We
that
can
is.
calculate, but we've not recovered, we've not attached for that amount. That amount is still, so when I show you the final statement of accounts, we've not included, we've said plus interest. Because it's monies that has actually should have incurred in interest and given to them. They would have gotten, the workers, when we paid them, they would have gotten interest because the PF gets interest. So it's out of our pocket and they have not deposited what they have collected the money since 77 is what they say on the basis of challans that they have submitted
And
before
how
us.
much have
And they
they-
have interest, they have,
How much money have they given to you?
88 is our without interest and they've paid 30 lakhs.
Okay, so 58 is still.
Yeah,
20.
spending, interest is separate.
So 88 lakhs is the
Approximately
principal.
88.9, I think 88.9 lakhs, minus they say 30 lakhs.
So
Pursuant to
30 lakhs
Honorable High
paid.
Court, this court's direction, they pay 30 lakhs.
30 lakhs paid.
Correct?
So interest not paid.
They paid more. I think I'll make my submission.
So interest of 15% has to be paid.
Yes, Your Lordship, 15% interest on areas till it is deposited. Yes, Your Lordship. Now, Lordship, since I'm at it, I'll show you the scheme, that it is them. We have no role in quantification. They have to file the form, they deduct, they're supposed to deposit to us. We are only responsible to tell them, please deposit. And we are responsible finally when the worker retires. The worker doesn't go to them, work comes to me. And I pay because it's a fungible. I'm a provident fund for all these stay, but at the end of it, I'm out of pocket. Your Lordship, the scheme is at page 14.
Yes.
Lordship, there's a composition of three. Lordship had asked recovery officer, trustee. So this is who we are. The composition of board of trust, executive committee, and investment committee. Lordship, page 19. (23) repeats the rate of contribution. What is important for me is procedure for collection. Just to point out,
Yes,
24, paragraph 24 of the scheme, the Lordship has paragraph 24?
that is page 20.
Yes, Your Lordship. Procedure of collection. The employer shall, in the first instance, pay in respect of the wage period, both contribution payable by him and also on behalf of the member employed by him. B, the amount of members' contribution paid by the employer shall notwithstanding any law for the time in force or any contract to the contrary. Please, Lordship, in mind. Notwithstanding any law for the time being in force or any contract to the contrary, be recoverable by means of deduction from the wages of the members and not otherwise. Any sum deducted by an employee from the wages under the scheme shall be deemed to have been entrusted to him for the purposes of paying the contribution in respect of which it was deducted. The employer shall deposit in a branch of the State Bank of India or Reserve Bank of India or any other nationalized bank, as the board may prescribe, the total contribution from himself and from the members employed by him, less such amounts as made under rules framed by the Board of Trustees be payable on closure of members' account in the fund or payable as an advance to member. E, a statement in the form of in Form 1 shall be submitted by the employer to the board with receipt for the deposit made in accordance with D above within a month of collection of the contribution. So it is them. And Lordship, then there's members' account. So we have no role in this amount.
So this board is the Board of Trustees of what?
Yes, Your Lordship.
Of
That is,
which you're.
yes, Your Lordship. Yes. We are the custodians under this act to whom it must be deposited. And at the time of retirement, it is our responsibility to pay provident fund to the workers of different tea estates. Which is why, Lordship, we were anxious that at least let there be, this will go, 2018, no coercive step. The tea garden, this Bogitola tea garden has not been functioning since 2017. So there are no workers. But there's Kalyani, which is working. And similarly, I don't think we've got any challans from them. So they're clearly a chronic defaulter. So let the law be heard. Let there be a determination of the amount. And it is their documents. If they say they've paid, we'll deduct in our chart. Lordship, may kindly take a look at page 53 of our IA, which is our final determination. Lordship has IA number, please.
IA. Okay.
IA 2845. 2845. No? 45.
Yes.
2845, page 53.
Page 53.
Yes, Your Lordship. Just to show you how we have calculated this amount. We welcome any dispute that we got it wrong. We're more than happy to correct it. But you have to come with documents. You can't just say I've paid. So, Lordship, this is what? Detailed default deposit of position of PF contribution. Lordship, see the subject? Subject. From 28/7/77 to 26/3/2016. That is when they were operating. So one is net collection. Administrative cost B. So total default is A. We include both of them. Then we have consider deposits made between the period of 77 to 16 as per records available at Golaghat Zonal Office as on date. And that's B, 89. Then we make balance A minus B is 81. So we have included 89 lakhs that they have supposed to have paid to the Golaghat Zonal Int. Then we say In addition to above,
Okay, so this is the amount.
yes,
basically.
yes.
That's all.
Yes, your lordship.
So altogether, according to you, around 85 lakhs.
And this is a prayer, yes. And we say in our IA that till date, they've not submitted any challan. And lordship, if I go through the writ petition, it is substantially a challenge on the amount.
Okay.
And they have in fact prayed that you've not given us an opportunity. That the recovery certificate is in between, the authorized and the recovery officer. Then after that, we're supposed to give a demand of notice. They've got everything now. They've got opportunity to come by, on direction of this honorable court, come to us with challan. They have not done that. May I read those one order, your lordship, to just give you a background of the reconciliation process, or lordship? Lordship, page 46, may I read the last comprehensive order of this honorable court? Page 46 of this IA. Order dated 30/5/18.
Yes.
Page 46. It's a long order because it talks about every order. First order is on 12/4/2018. Lordship, you find that it's extracted. Heard Mr. Tiwari, so and so, the dispute essentially lies with regard to area amount payable by the petitioner company on account of Provident Fund, etc. Last two lines, while an amount of 88 lakhs under recovery certificate issued under 15 is stated to be due, such amount is seriously disputed by Mr. Tiwari. Lordship, then of this paragraph, the last 5 lines.
Yes.
Okay, he submits that it is a fit case where a direction should ensue from this court. This is his submission. To the parties to reconcile the dispute relating to the areas to be paid on the basis of records maintained by both parties, and to that extent, petitioner has already filed a representation. So we move the IA that if this is a submission, let it be reconciled. He's not willing to reconcile interstate, so let a third party do it. Then he says, he has undertaken an exercise of his own and found that it is only 32 lakhs payable, which it's duty bound to pay, of which 10 lakhs it has paid. Then page 48, your lordship, it goes on and it's a second paragraph. In view of the submission of Mr. Tiwari, learned counsel is requested to furnish copies of the aforesaid compilation to Mr. So-and-so. Parties are at liberty to sit together and work out. This is the first order. Then comes the second order. Subsequently, on 4/5/18, the court passed the following order. And it notices the second paragraph of this order. It appears parties could not sit together and there was some communication gap between the parties. During the course of proceeding today, the learned senior counsel appearing for the parties suggested that this court may itself consider fixing time and place. So it's gone to that extent. Then next, in view of the matter lordship has, without any formal notice, the petitioners and authorized representative may sit. So the court fixed the time of 14/5/18. During the meeting, respondent number 2 made available basis, outstanding details, etc. and can point out everything. Lordship, page 49. Then it says what happened. Second paragraph, page 49, second paragraph. Pursuant to the meeting on 14/5/2018, which was fixed by the learned court, in terms of order dated so and so, an affidavit have been filed indicating the outcome of the meeting. Perusal of the affidavit go to show there was no meeting point, and the parties sought to blame each other for such failure.
Okay, one thing, as per the 1955 Act,
Yes, Your Lord.
is the amount that has to be taken as Provident Fund the same? 12%.
Yes, 12%. That has not been changed, no.
And the manner in which
Yes,
it
Your
was to
Lord.
be done was as per, yes.
Yeah, section
Yes, it
15 was land revenue areas and has become now.
So
attachment,
section
etc.
15,
Yeah.
prior to the amendment,
Yes,
would require the method followed in the,
DC as a land revenue.
so that would mean the Bengal Demand Recovery Act.
Lordship, yes. Lordship, the IA submission is, okay, let that be the procedure.
Okay. Let that be the
Let's
procedure.
proceed without admitting, Your Lordship, not at all without admitting. Assuming that is the procedure, tell us the amount. Show me challans of what you've paid. What I showed you, page 33, is on the basis of documents they have filed. We don't have documents, Your Lordship. This is Form 1, which they filed. And this is challan. I showed you Form 1, Your Lordship, in the scheme. Para 23. And Lordship, I can show you the Form 1. I've annexed it. Form 1, put us in page 20 of my IA. And I showed you in the scheme that this is what they have to do within a month of their collection. So even if it's Baki Jai, let my prayer in the IA be amount be determined. What the court tried to do couldn't do because two of us couldn't reconcile. So let there be a third party who Your Lordship deems as best and determine. Then after the amount is this thing, then we'll decide which let it be Baki Jai, let it subject to hearing on law. And Lordship, Supreme Court has done that.
But can we direct the third party to?
Supreme Court has done it, Sapre Committee. And exactly, Lordship, this is a chronic problem with tea plantation owners. When they can't run it, then they go. So I think it was West Bengal, Kerala, Assam. So finally it went up to Supreme Court, order by Assam. So they went
No, but Supreme Court may be able to do it. Can we do it? Do we have the power to do it? Ask a
Lordship,
third party to do it.
otherwise their writ petition should be dismissed because
Ah.
how does your Lordship,
Unless
I'm
they
making
can,
a prayer.
unless they can produce documents.
Lordship, but in 226, we can't expect your Lordship to
Go
look
through
at-
all that.
Yes, your Lordship. So my application actually is in aid of is against me and in aid of their writ petition. If it's such a disputed question of numbers, my attachment order should not be stayed. And these are, Lordship, with respect, these are amounts of money earned by people. They've worked, laborers, earning 6,000 to 15,000
Okay,
a month.
I think we'll hear the petitioner now.
Yes, your Lordship. Obliged.
Yes, Mr.
With
Tiwari.
the help of their documents, my lord, I will show that there are documents issued by them wherein they had quoted a much less figure. And on the contrary, my lord, we filed our statement wherein we showed no, not this amount, but a more amount is payable by us.
So,
And
but
my lord, out of that, substantively we paid the money. I am going to show all that. The difficulty, my lord, here is, my esteemed colleague, my lord, would bear with me.
Sorry.
Have
No,
patience.
I didn't mean to interrupt. Sorry.
No.
No, I just want to make one point, please to innate. We welcome that we are wrong. Lordship, I am happy to be told that I'm wrong and my figures are wrong. But I just need to be told with figures and challan. That is it. So I'm not disputing that I could have been wrong, is my submission. Sorry, I didn't mean.
Very nice, okay. So factual part, my lord, I will deal with. So far as the legal aspect is concerned, to begin with, my lord, only few things I speak, namely, number one, when the procedural part completely does away with the opportunity of hearing, the compliance of the principle of natural justice, it becomes substantive. The 1955 Act 2016 amendment completely abandons the very path of compliance of natural justice. And I would not say completely abandons. In fact, there was no machinery as such in the 1955 Act. The machinery was in the 1913 Act. And 1913 Act machinery provided for an opportunity of hearing for the compliance of natural justice, something which was not the case with the 1955. I'll come to all that. I'm just below giving the framework.
No, I need to know the framework.
Very well.
You know everything. I have got to start from the skeleton,
Very
then
well,
put
but
on the flesh.
Then systematically, once I present, then my lord, let us straight away come to the issues. There are three fundamental issues involved in this case, so far as the point of law is concerned. And I'm presenting those issues. The issue number one is, since my lord is taking notes, now I'm not presenting the issues.
Yes.
Issue number one is whether provisions of Assam tea plantations, provident fund and pension fund and Deposit Linked Insurance Fund Scheme Act 1955 and its Amendment Act 1916 can be applied to the pending Bakijai proceedings initiated under the provisions of Bengal Public Demand Recovery Act 1930. Pending proceedings under the 1913 Act straight away taken away under the 1955 Act by 2016 amendment. More so when the Act is silent. When the Amendment Act is silent, the pending proceedings will be covered by it. I'll come to that part. The second issue is,
give me those issues.
my lord, I'll get it typed and
You just mention it, he'll just write it down. Yeah. Anupam,
please.
you just take it down. Yes, the first one.
Yes. Issue number 1, whether provisions of Assam Tea Plantations, Provident Fund and Pension Fund and Deposit Linked Insurance Fund Scheme Act 1955 and its Amendment Act 2016 can be applied to the pending Bakijai proceedings initiated under the provisions of Bengal Public Demand Recovery Act 1913. 2. Whether the proceedings initiated under the 1913 Act for recovery of arrears of Provident Fund but was quashed by the order of the Honorable High Court on the ground of violation of Section 10 of 1913 Act with liberty to initiate fresh proceeding in accordance with law could be reinitiated under the amended provisions of a different legislation which came into effect subsequent to the order of the High Court. Because the order of the High Court attained finality. 3. Whether amended provision of 1955 Act, which came into effect in 2016, could be retrospectively applied for recovery of arrears of Provident Fund covered by Bakijai proceeding under the 1913 Act. No, my lord, my lord will have this list of things. Please.
Thank you.
Lord, I'll just so, my lord, these facts will be very relevant for our case. Period 1993 to 2007. Respondent 1 and 2 initiated Bakijai proceedings for recovery of arrears of Provident Fund against the petitioner company under the Bengal Public Demand Recovery Act 1913 in the Court of Certificate Officer Golaghat. Bakijai proceedings were in respect of the following recovery certificates. We have given the details of the recovery certificates. Then, my lord, a note we have given below it. However, so total amount was 49,48,000 such and such.
So these are still pending.
My lord, I'll come to that. It's all closed. However, from verification of records, the said amount ought to have been around 34,61,276.91 approximately, wherein a sum of rupees 14,86,731.12 was erroneously added while preparing the recovery certificates, and as such, denial petition under Section 9 of the 1913 Act was filed by the petitioner. So under the Bengal Public Demand Recovery Act, we filed the denial petition. Meanwhile, petitioner paid
One thing, Mr. Tiwari, straight away I find the addition is wrong. When you look at the first paragraph, you can see the 49,48,000, correct?
Yes.
Now, when you add 34 lakhs and 61, okay,
That is why
correct.
14,86,000 was
That's correct.
erroneously added.
Okay, then,
That's the reason. So, my lord, denial petition was filed under section 9 of the 1913 Act. Meanwhile, petitioner paid to certificate officer Golaghat on account of Pakijai cases a sum of rupees 17 lakh 37,678 from time to time, and also made full payments in certain cases amounting to rupees 6 lakh 17,678. This is, we have shown in which additional affidavit we have said so. Then 31/3/2005, the subdivisional magistrate cum certificate officer Golaghat passed an order dropping the proceedings in Pakijai case number such and such, covering the period prior to September 1991. In their Milord calculation, finally they have shown everything, even of the amount which we had paid. They included everything. So covering the period prior to September 1991, moreover, by the said order, the following Pakijai cases were allowed. Pakijai case number such and such, from 2005 to 2008, with the direction that installments for all these cases should not be less than 20,000 rupees. This is Annexure 11, page 33-34 of the writ petition. I'll just place it. Annexure 11, page 33. Typed copy, my lord, will find at page 34.
no, so what do you want to show by way of this document?
Just the amount that the amount about which there should be no dispute. What we have paid.
Okay, so.
Clarity
okay.
on that. Anyway,
Okay, so
I'll skip it.
We can skip
Then
on-
my lord will come to 25/7/2013. The proceedings in the leftover Pakijai cases, wherein the petitioner had denied its liabilities by filing a petition under section 9 of the 1913 Act, were challenged in WPC 2463 of 2007. The said writ petition was allowed by this honorable court by order dated 25/7/2013, holding that the Pakijai proceedings were initiated against the petitioner in contravention of section 10 of the 1913 Act. As a
No,
petitioner,
those are all right, those are all facts.
my lord, this
Now-
order will be relevant because the order of the High Court attained finality.
Huh.
Because the moment High Court says, because of violation of section 10 of the 1913 Bengal Public Demand Recovery
For
Act.
these cases.
Yes, so it should be, liberty is given to initiate afresh. I ask myself a question as to whether, even in such a case, whether these Pakijai proceedings could have been reinitiated under the 1955-2016 amendment of a different legislation. Order of the High Court attained finality. Whether liberty to initiate fresh proceeding in accordance with law
Okay,
would
now,
ipso facto mean that a different legislation could be applied, which was amended 3 years after the order of the Honorable High Court. Because apparently, my lord, even these figures they have taken into consideration. They have included everything.
okay, leaving that aside.
One.
Now, the issue basically now is that you have to pay a certain amount according to them. Now, is it your case that you have got to pay a certain amount or you have paid everything?
My lord, substantively, we have paid maybe 6 or 7 lakh rupees might be required to be paid. I just made the calculation. My lord will come to the last page. The date is 30/5/2018. Last two dates, 30/5/2018 and 29/10/2018.
Yes.
30/5/2018, I read first. This honorable court passed order in this very particular litigation. The honorable court passed an order noting the fact that though an amount of rupees 88,90,961.81, this is the amount my esteemed colleague is quoting, under a recovery certificate issued under section 15 of the Assam Tea Plantation Provident Fund and Pension Fund Deposit Linked Insurance Scheme Act 1955, is stated to be due from the petitioner company, but according to the petitioner company, the Deputy Commissioner Golaghat, in his letter dated 26/12/2016, and my lord, we have annexed this letter of DC Golaghat, addressed to the Secretary, the Provident Fund Commissioner Board of Trustees, APTF organization, had submitted that only an amount of rupees 49 lakh 7,608.73 was required to be paid by the petitioner. However, the statement furnished by the petitioner company before the honorable court, because court asked us that you also submit a statement. What is payable from your side? However, the statement furnished by the petitioner company before the honorable court showed the arrears of rupees 49 lakh 71,112.16, which according to the petitioner included an amount of rupees 17 lakh 37,678, which was deposited before the certificate officer Golaghat in a Bakijai case. We have given details of that also in earlier part of this resume. On these facts, the honorable court directed the petitioner to make payment of a sum of rupees 23 lakh within 31/10/2018. And my lord, accordingly,
And
we
this-
paid 23 lakh also. We paid that. So my lord, 49 lakh, 17 lakh, my lord, we deduct, it would come to around 32 lakh, from 32 lakh, 23 lakh we have already paid. So going by that, maybe my lord, 7 lakh or 8 lakh rupees.
Now,
Nothing else.
so that is your case. Now, the thing is that how do we come to a clear figure?
Clear figure, my lord, because if the proceedings are allowed under the Bengal
Can-
Public Demand Recovery Act 1913,
No,
here,
no.
my lord, there is an opportunity of hearing. So collector, my lord, is a competent authority,
Or-
an adjudicating authority. The collector, my lord, the moment figures are disputed, amount is disputed, collector has the mechanism to arrive at the right figure, but maybe by appointing a commissioner.
As per this new,
There is no opportunity of hearing. It contains
No,
stringent
so why
provisions.
don't we appoint a arbitrator? Both of you,
Up to my lord.
if both of you all agree, we can appoint anyone, a district judge or anyone, and you settle and pay according to that.
But my lord, we have no difficulty so far as that aspect is concerned.
Because that way,
Only
even-
problem will be whether my lord, because it requires a certain degree of skill in auditing and accounting. So whether my lord, the concerned district judge or retired district judge will be able to, my lord, go
No,
into the,
I think, you see, you've got no choice.
well, very well.
Otherwise, because even if, you see, disputed questions of fact, they all go to district courts, but we have got no clue.
Very well.
But then they have got, that's the best we have.
Possibly, lordship may.
So, I said, I think if they're agreeable to both of you,
Then we settle on a, mutually we discuss if an arbitrator, if we can jointly, my lord.
Yes, please.
Repose trust on a particular arbitrator,
Correct,
something like
correct.
that.
Just give the list to them.
Justice BK Sharma?
Well, no difficult.
Justice BK Sharma?
No, BK Sharma is not.
We will have to work hard. My lord, I may have to work hard.
No, you might,
Give me the task of making all calculations.
you might, you just see from there.
Then my job will become difficult.
Give one more copy.
Technical experts would be at least.
You can have a district judge also, it doesn't have to be a high court judge.
Justice Sapre did it for 3 states. So it's not technical, it's actually a challan. Have you paid, have you not paid? They have to just show that, it's documents. It's no other accounting computation.
My lord, when I get some time, we will.
Yes,
pass on
sure,
same
sure,
to your lordship.
sure.
We'll just discuss.
Yeah, we sure.
Because, we'll discuss, my lord, and we'll settle on a particular name.
Ah.
I will let my lord know, my lord.
Yes,
I'll
yes.
tell them.
That way, everyone will have an opportunity of being heard also.
Very well.
Yes, sir.
Okay, right. Heard Mr. V.K. Tiwari, the learned senior counsel for the petitioner, assisted by Mr. A.R. Gogoi. Miss
G Goswami,
appears for
it is respondent, all respondent, no?
all respondents.
All respondent. No. Authorized officer. Yes.
Okay, then you're right. The
Sorry, 1 to 4.
1 to 4.
Yes.
But about Miss, what is your submission? Lockout?
Yes, Lordship, in the petition itself. So, we are on this, something else, Lordship, and accordingly, we have filed our affidavit also stating all the facts. Uh, Because there are certain rounds of reconciliation procedure also, Lordship, so that the lockout can be taken away, Lordship, and all this. So we are on that only. Because the laborers who are actually working in the tea estate, Lordship, they have become jobless.
That
This
is, that is
and-
a different issue.
Yes, Lordship.
That is a different issue.
But
That
this
is
has been raised in the writ petition also.
maybe it is, but that is
Yes,
not an
Lord.
issue. Is there an issue here? Is there a prayer?
No.
Attachment order.
Only attachment order.
It is,
Lordship.
then that's a different issue altogether. This is with regard to the company. His prayer
But
is,
after the attachment order has been issued, Lordship, there was some, there were some deliberations between the management and the district administration also, Lordship, to reconcile all these things, Lordship. But they have moved back from this.
okay. Okay, right. Right, huh? Third sentence, so then the dispute in the present case is with regard to the arrear amount payable by the petitioner company. The arrear provident fund amount payable by the petitioner company. While the case of the while the case of the respondents number 1 to 4 is that the petitioner company is to pay an amount of rupees, how much? 88,
0.9.
88 point, approximately 88.9 lakh.
Respondents category.
Yeah, I know.
88.9.
That's what I said that. 88.9 lakhs, approximately 88.9 lakhs. Comma. Without interest, without counting, without calculating the interest, comma. The amount payable by the petitioners is approximately 6 to 7 lakhs.
Yes.
6 to 7 lakhs.
But one correction, 88 minus 30, you paid the
No.
cost of the hearing, you paid.
No, no,
You
no. I
rely
thought
on your document.
No, this,
that is his, you see, those things.
yeah, okay, you're actually, yes.
He can say anything, he can say 0 paisa also.
Likewise, both ways.
Yes, both ways,
Both ways.
both ways. Right, next. The petitioner's counsel submits that while there is an issue with regard to the quantum of area provident fund to be paid by the petitioner, the other issue pertains to the procedure to be followed in recovery of the alleged area amount. First up. Next para. The counsel for the parties have taken this court and have made submissions with regard to the issue, we have made submissions with regard to whether the mode of collection of the provident fund that has been undertaken by the respondent is prospective or retrospective in nature. First up, however, during the course of arguments, the counsels for the parties have agreed that the matter can be resolved if the dispute between the parties with regard to the amount of provident fund payable by the petitioner is resolved by an arbitrator. Correct? Resolved by an arbitrator. In terms of the Arbitration and Conciliation Act 1996, hereinafter referred to as the 1996 Act.
So not only one prayer, since there is a lockout in the company and by order of attachment, their office is already sealed. All the document records are in the office. So that liberty may be given to us to have an access to the office and to get the records. Otherwise, it will not be possible. How do we get that? That's the whole.
Any problem, madam?
Actually, that lockout is not, lockout is the district administration, not lockout by others.
Actually, you have to write Miss, you've written her name also, no? Okay, right. However, Mr. P.K. Tiwari, the learned senior counsel, submits that as there is a lockout in the company office, as there is a lockout, all the documents of the company are sealed. And unless an order is passed by this court to enable the petitioner to take out documents in support of their claim with regard to the payment of alleged arrears of provident fund, the arbitrator also would not be able to resolve the issue between the parties, resolve the dispute between the parties. Next. The counsel for the parties have both agreed to, who have you agreed to? Any? Okay, you are going to consider.
Arbitration is court commission, not arbitration. It's not just arbitration or is it like court commission?
Court commissioner.
Court commissioner, no, it depends upon you.
Would be better because arbitration.
Okay.
Court commissioner.
Okay, accordingly, you will change instead of arbitration, then you cut all that arbitration. Accordingly, as per the consent of the parties, counsel for the parties, Mr. So-and-so is appointed as the court commissioner to resolve the dispute between the parties as to the actual amount of provident fund payable by the petitioner to the respondents number 1 to 4, if any. Full stop. The above being said, the state respondent authorities shall permit the petitioners to take out documents from the offices of the petitioner company for enabling the court commissioner to decide the issue, the dispute between the parties. However, the respondent authorities may record the documents that are taken out by the petition at the time of allowing the petitioner to take out the documents from their office. That's all.
That's in the presence of the state administration, they will go.
Naturally,
Naturally. I said they will record.
Yeah, that's it.
They have to record everything.
there is only one aspect which is troubling me, namely that let us presume that some figure will come out. This is required to be paid or that is required to be paid. Now, in that eventuality, my lord, if there is a dispute, because the forum would be equally important.
That is why I said arbitration, because there is an appeal provision under 34.
My lord,
But of course, you'll have to pay. But then you all don't have money.
that's one. And number two, my lord, because here the amount is so less according to us, there would be a feeling in the mind of a party as to why should I spend so much of money. Court commissioner,
Keep the reputation pending.
repetition may not may remain pending because the question of law may not would be relevant.
Okay, no
Because-
problem.
Because the case of the party
We will keep it pending, no
it is
problem.
covered by the Bakija.
No problem, no problem.
Very well. At least some figure.
But how will that person be paid?
May not, workers are also not there, whether they will have to trace out the workers.
I
Many of
think
them have already
that
disappeared.
I think
By
that
the party, we have to pay, right?
Huh?
The court commissioner you're talking
the
about.
court commissioner,
Has been shared by party.
yeah, that's what. How will the court commissioner be paid?
By the party.
parties.
No, no, that we will decide and will not be.
They'll have to,
So,
they'll have to deduct the fee of the senior council a bit.
you know, city council won't be appearing there. Somebody else will be there. I won't be there.
Okay,
So,
then,
we will decide who will be the court.
so
commissioner.
in that, no, that's why I've left it blank.
No, no,
The
we
period,
need not stick to this in that case.
no,
We
you
need
don't
not
stick,
to
no,
this.
no, no.
Very well. We'll settle on
Uh,
something.
the,
One more prayer.
uh,
Decide.
no, how much will be the fees?
Mutually decided.
Okay,
Actually, will not be ask the court commissioner also. because
okay.
Let him be.
So I will not put anything in there. Is there time limit required?
Yes, your lordship.
How much?
3 months from date of appointment. Accepted, not appointed, accepted.
You know, I don't know quite by the whole problem, whether 3 months will be enough or not. Court commissioner may feel easily difficulty.
In 77, there is.
We don't know. That is also being disputed.
Okay, we'll give 5 months.
Very well. Let it be on safer side,
Right.
5 months. When so much of time has gone.
6 months, your lordship.
Let it be 6 months.
Okay, right. The court commissioner shall take a decision on the dispute between the parties after acceptance of the, after acceptance of the, from the date of receipt of a copy of this order. And submit a report, and submit the report to this court thereafter.
Consent, your lordship.
From the
accepted.
date of consent, of being appointed as the court commissioner.
Revenue, he should only decide and tell us instead of there being a fight about that.
The court commissioner should also decide the remuneration that is to be paid to him prior to giving his consent to taking up the assignment.
Yeah, well,
Then list the matter after 6 months.
Right, your lordship.
Hope something comes out.
that's so.
We come back and give the name.
Yes, we'll just find out.
Oblige.
Then this IA, what is this for?
Yes, IA can be disposed of.
Right.
IA was
Then-
meant for this.
You make this in the IA only. Then you say IA is accordingly disposed of.
Yes.
Then in the main case, you say in view of the order dated today, 8/2 to list this matter after 6 months,
Oblige.
awaiting the court commissioner's report.
Right.
My lord, in this case, my lord,
Put this in the main case. They want this. I don't think, they'll want it back, I think. Otherwise, it'll get lost. 6 months, it'll get lost.
yeah, please, look at, in this case, my lord, despite my lord, the work order, interim order passed by the honorable court, my lord, the exponent ONGC, my lord.
You keep this in the file. This is what?
My lord, despite my lord, interim order passed by the honorable court, my lord, on 4/10/2023, my lord, the respondent ONGC, my lord, issued my lord, the work order, my lord. So, my lord.
Just a minute, let me find out the file. My item 6.
6.
Is there an interim order?
Yes, that's it. Despite the interim order passed by this, respondent ONGC, my lord, issued my lord, a work order, my lord. So, my lord, petitioners filed my lord, a contempt petition, which is listed, my lord, tomorrow, my lord, the item number 3, my lord. My lord, let the matter, this matter, my lord.
That has nothing to do, my lord. Your lordship, my lord, because you are suffering because water tankers are shortage, my lord. We have, my lord, originally given, my lord, they kept 2 because petitioner, because on the day, my lord, they have issued those for us. The second half, that order was passed, but they have issued work for us there. That has nothing to do. Today, my lord, this matter has been issued several times, but we are suffering, my lord, there because one person has not placed the tanker. And so for water tanker, we are suffering. So let this matter be decided. Well, in that case, it's nothing to do. Notice may be issued, my lord. That is another aspect of matter. We cannot appear.
Both of action, my lord, same.
We cannot appear, my lord, in the contempt. Let them go there.
But subject matter is same.
This is, my lord, this matter, my lord, it's a short matter, my lord.
What is this matter?
Once your lordship dispose of this matter, my lord,
My lord,
then again they have come.
my lord, 10
Acha.
fix my lord at 2, my lord, because my lord senior council must have 10, so we declare my lord. At 2.
Let us see the order passed
Yes, lord.
by this court earlier.
410, my lord.
Huh?
410, 2020.
Yes,
Paragraph 6, my lord.
yes.
It is stated, my lord. Having regard to the project made provided that 6/10/2023, the exponent IFCL authorities shall not undertake any further process in terms of the price bid opening statement dated 26/9/2023. But my lord, same day, my lord, the respondent was issued the work order.
Same day.
Same day.
So maybe they did not receive it in time.
My lord, this order was passed in the second half, my lord. I
So,
was there.
so how does it, so the contempt was there.
Yes, tomorrow, my lord.
So-
Item number 3. my lord.
Moreover, my lord, we have kept two, my lord, they submit a tender for 2 tankers. 2 tankers reserved, my lord. We have, because the dispute was there. So 2 tankers were not allotted. 4 tankers were allotted, out of which 1 was also not placed. That has not been given later because of this in the order.
Well, petitioner
Only
is not
2
L1.
tankers, my lord, running.
Petitioner
So-
is not L1, my lord. My lord, late command, my lord, at
Well-
my lord.
Well, this is matter, my lord, we are suffering, my lord, what
I don't understand. What is the case about?
yes, my lord, here, your losses see, my lord.
You're the petitioner.
Earlier, my lord, this honorable court disposed of the matter, my lord,
Yes.
once.
Wait.
I shall place that also. That, then, my lord, they have come again, my lord. It will take, my lord, within, short period, my lord, it can be disposed of, my lord. Hey, what is it? I got
272.
272, lord, yes.
Yes, my lord, this was your loss. The same matter, my lord.
No, so what has happened actually?
Well, thereafter, well, they say that the IOCL rate is not available. But later on, they say that from the IOCL website, they have collected the rate. Now it appears that was not the IOCL rate. My lord, I shall come to that, my lord. If you also see. in
But
the-
he says that he was his senior.
My lord.
At what time? 2 fixed something. Oh, we've already fixed some other matter at 2 also.
Well, this is very important. They are various dates, time has been taken. That is why.
What to do? This bench, what to do? We have got to hear all matters now. What to do?
But this will not take much time, my lord.
Okay, we'll try, but then we've already fixed some other matters. You'll have to take a chance. Because 3:30, we have got a full bench. 3:15, we have to write. 3:31 bench is there, full bench.
Well, can we take it up at 2 as part or it will not?
2 though we have already fixed. In the morning, they had prayed. So already fixed. Item 7 and 8 already fixed at 2 o'clock. What to do?
My lord, in that case, I can only say about the subject to the outcome of the.
You
case
can
or-
wait, you can wait. You can wait. Let's see if possible, we'll take up.
My lord.
Okay. Next. Ah. Correct. How come they're not missing? They're not here? No, that 3 years experience was. No one here, next. No one appears for the petitioner. According to this matter after 2 weeks. 23.
Please on report. Lord, in terms of notification 91,
Today we were to propose the name of the arbitrator and my friend
I
had
don't know if
taken
your
time
lordship-
for instruction.
I
Yes.
beg pardon of your lordship, I have been engaged with your lordship. The respond number 2 here, your lordship, she is in her advanced stage of pregnancy, your lordship.
So?
She is in Lakhimpur, your lordship. However, there was some miscommunication with the earlier set of advocates, your lordship. That is why, your lordship, I have been asked to, your lordship, I need to see with her, your lordship.
Huh?
I need to have some, your lordship, discussion and instruction from her, your lordship, personally. She's in her advanced stage of pregnancy. That is why she is unable to, your lordship, come to Guwahati.
He doesn't need to come to Guwahati.
Your lordship, but even then, your lordship, there are some issues, your lordship, that to be, your lordship.
What issues? The only issue here is if there is a dispute.
Your lordship, that
And-
is true. That is
And
true.
if there is a dispute, there is an arbitration clause.
Your lordship, if your lordship goes through the arbitration clause itself, your lordship, at page 29 of your lordship, the
Yes,
petition, your lordship,
yes.
that 25 clause 25, your lordship. There
Yes.
is no specific provision, your lordship, to appoint arbitration single arbitrator, your lordship. That may be Peru, your
Why
lordship.
not?
Your lordship. May I read it, your lordship?
Yes.
That all the dispute and questions in connection with this presence or to be partnership property rights, credit or effects or any of the partnership account, business or transaction, whatever arising between the parties hereto and their legal representatives, whether raised during the continuance of a single arbitrator, your lordship. Where is the question of, your lordship, appointing an arbitrator, single arbitrator? Is
Why?
there anything specific, your lordship?
No, it says continuous.
During the continuance of a single arbitrator, your
So,
lordship. That
look,
has
Mr.
not-
Counsel, just because the person who had drafted this
Your-
has not clarified it, please give me another interpretation of this clause.
Your lordship.
What does it mean?
If outside of this, your lordship, partnership agreement, we mutually decide, your lordship, as a clause. If we mutually decide, in
Eh.
that case only the single arbitrator will come, your lordship.
Mr. Counsel, there is a provision called section 11(6).
Your lordship,
If you do not agree, then the court can appoint.
your lordship, that is why, your lordship, I need to, your lordship, some more.
So
clarification.
that is not a question of you agreeing. It is because you don't agree
Your lordship,
that he has filed a 11(6) application.
your lordship, that has to be, your lordship, admitted that there is a specific clause, after that only.
No,
lordship-
it is implied. Just because your drafting is bad,
Your lordship,
doesn't mean that it is not implied. It does not imply that you have got to go to a civil court. Does it imply that?
no.
No,
that is
then
not
what
the-
is the, just
Your
tell me, what do you understand by this clause? Does it mean that you have to go to a writ court or to Supreme Court, or where you are supposed to go? What is this clause 25? It
Otherwise
basically,
also, your lordship,
it-
otherwise also this clause is not specific about appointing. an
we
arbitrator.
will interpret that.
Lordship, that is why, your lordship, I need to file an affidavit, your lordship.
No affidavit.
Your
No
lordship,
need affidavit.
otherwise
What
I will
affidavit?
sir, allow some more time, your lordship. Otherwise, your lordship, this will miscarriage of justice, your lordship.
There is
giving
no
the
miscarriage
proper
of
lordship,
justice.
your
There is
lordship.
no miscarriage of justice. There is no miscarriage of justice, sorry. You can always file an appeal.
Sui generis, my lord. The term sui generis should be perhaps.
You can always file, you can always file an appeal.
Your lordship, I'm just praying for some time, your lordship. Nothing-
You are
Your
praying for,
lordship, decide-
you are praying for an affidavit, no question of an affidavit. You talk to your client
Your lordship.
if you want.
I'm praying for
Well-
some time, your lordship. Moreover, your lordship, my senior, Mr. Ash Sharma, he's also out of his nation.
No, where is your wakalatnama?
There is no wakalatnama.
Where is your wakalatnama?
Your lordship. My name
Where is your wakalatnama?
reflected there in the cause list, your lordship.
Causeless.
Yes,
Have
I
you
have
filed,
done
have you
that.
filed your
Yes, your
wakalatama?
lordship.
When?
Yesterday, your
Yesterday you have filed.
On 7th, your lordship.
Huh?
7th, your
Seventh is yesterday. You filed it yesterday. Is it
Not
here?
on record. I think Mr. Datta's name is shown, my friend.
My name,
Mr. Datta's name is
no, no,
shown.
my name is Rimshod.
What is your name?
E. Ahmed, your lordship. Ash
Sorry, your
Sharma,
name
E.
is
Ahmed.
not here. Your name is not here.
It is reflected in the cause list, your lordship.
Huh?
It is reflected in the cause list, your lordship.
Causeless.
Yes,
Supplementary.
Supplementary cause list, your lordship, item number 23, that may be seen, your lordship.
Mr.
E. Ahmed,
E.
Ash
Ahmed,
Sharma,
yeah.
and
Yeah, Ahmed. Yes, Ahmed is there.
it is there, your lordship.
You obtain instructions.
Your lordship.
You see, these issues cannot be decided by a writ court.
Yes, your lordship. I can understand that, your lordship.
So it has to go
Your lordship.
as per the clauses of the agreement. Now, you can interpret section 25, clause 25, however you want. We will decide whether
Your
your interpretation is correct or not.
Your
That's all.
lordship, it's always up to your lordship.
Naturally,
to decide.
so if this is a question of law. Where is the question of filing an affidavit? Affidavit is only for facts, not on law.
There's no disputed fact.
Some other facts have also been your lordship here. That is why your lordship.
Those facts can be placed before the arbitrator. Why bring it before an
Then why your
arbitration
lordship,
petition
all the
or
facts has been your
appointment of an
lordship.
arbitrator, my lord?
Why, then why all the facts has been incorporated in this petition, your lordship?
For
I don't
that
understand.
point of, that is to be
That
placed.
could have been simply, they could have.
Mr. Counsel, there was a lawyer earlier also.
Yes, your lordship.
Okay.
I beg pardon, your lordship.
Raise these points as a fag end, my lord, when the appointment of the arbitrator is agreed upon yesterday.
The reason for an arbitration clause is so that there is a, quick disposal of the dispute.
In a gentlemanly fashion.
Oh, whatever.
Arbitration is
expresses are
matter
also
of
involved, your
gentlemen
lordship.
and ladies, my lord.
Expresses are also involved.
We'll list it next week. You get ready. Mr.
Yeah, Ahmed, your lordship.
Yeah, Ahmed, Learned Counsel for the response number 2 and 3. Praise for time to obtain the instructions. What instructions? I don't know.
Your lordship, she has to come 15.
So what? She's pregnant. How does it matter? She's pregnant.
Can be conveyed on
I
telephone.
pray your lordship.
She's sick. She's pregnant. So what? She can't talk to you over the phone. How did she sign the Wakalatnama if she was pregnant? You went there. She came here. How did you do it?
It has
Huh?
been said.
Or you did it yourself?
No, your lordship, it has been said.
And when did it do? When did she do it? This order was passed day before yesterday.
Your lordship, on that day itself, your lordship, I filed the vocal.
On the day itself. How come it's not here?
It has been filed, your lordship.
Let me see, is there a second copy or something? Huh? How come his Wakalatnama is not here, but his name is here in the course list?
The entry has been perhaps made in the computer, your lordship.
Maybe,
Then that
yeah.
has not come to record.
Okay, whatever I said, then counsel for the respondent number 2 and 3.
1, 2 and 3.
1, 2 and 3. Is given a week's time to obtain instructions and file affidavit if necessary. It is also noticed that as per the last order, the earlier counsel for the respondents was to obtain instructions with regard to the appointment of an arbitrator, single arbitrator. List the matter on Monday.
Monday.
12.
Can it be after 14th, your lordship?
No, today's what? Today's 8th, huh?
I beg pardon of your
19th,
lordship. Can
19th.
it be after 14th, any date, your lordship?
19th?
19.
Give it enough time.
Oblige, your lordship.
14th is for that.
Oblige, your lordship.
Wait, please, your lordship. I seek to indulge your lordship on the matter 9 to 11. My senior was on legs, I was on legs, your lordship can kindly take up the matter, your lordship. 9 to 11, your lordship. I beg before your lordship.
You know the envelope, you know? No. Yes.
Yes. Your lordship, 9, item number 9 is WPC 6588.
Yeah.
Item number 10 is 6589 and item number 11 is 6591.
So all of them are similar?
All of them are similar. Your lordship can take up item number 9 as a leading case, your lordship.
Yes.
Yes. Your lordship, the petitioner is a manufacturer.
Manufacturer of what?
Manufacturer of agricultural products, your lordship.
All the writ petitions.
All the writ petitions, your lordship. There are bigger categorizations. Item number 6588 of item number 9 is for supply of micronutrients.
Okay, so the different tenders.
Different, broad
Okay,
categories.
just a minute.
Yes.
So the first one is for supply of
Micronutrients.
micronutrients.
Yes.
And then the second one is for
Is for biofertilizers.
supply of
Biofertilizers.
Third one,
And 6591 is for weedicides and
Huh?
pesticides. Weedicides and pesticides.
weedicides.
Yes, weedicides.
How do you spell?
WEEDICIDES.
TS,
DES.
DS,
Yes, weedicides
weedicides.
and pesticides.
Okay. Ah,
Yes.
oh, today. Oh, where is it? Almera, I'll take it out.
Ah. If I may submit your lordship.
Yes.
Yes. Your lordship will
Who
kindly
is
come.
for the other side?
Mr. Chaudhary, your lordship, is probably on, he'll be on his way, your lord. He'll be on it. It's slightly pressing for the government. Also.
Ah,
Yes, there was a case of allotment of funds.
yes,
Yes.
then,
Yes.
so,
Your lordship will kindly come to Annexure B,
page,
page 20. The Annexure B starts from page 20. It's the NIT, your lordship. The relevant page is page 31.
e-procurement notice.
Yes. Then your lordship will kindly come to page 30 and 31. Your
Yes,
lordship-
ma'am.
Yes, yes.
E-procurement notice dated,
Dated 25/10/23.
29/9.
25/10.
No, where do you get 25?
29/9/2023. Yes, your lordship.
Yes,
Yes. Thereafter, your lordship will kindly come to page.
it's a two-bit system.
It's a two-bit system, your lordship. Lordship will kindly come to page 30.
30.
30.
Yes,
The lordship sees bidders eligibility at the bottommost clause, your lordship, 2.5.
yes,
Yes. Bidder shall be a single business entity having a formal intent and legal competency to enter into an agreement or contract and are registered under respective act in India. 2.5.2. The bidder shall be one of the following categories of entities to be eligible to participate in the bidding process. The first category is manufacturer of the goods. The second is authorized dealers or distributors of the manufacturer of the goods. And the third is authorized importers of the manufacturers of the good. The petitioners in item number 9, 10, 11 fall in the first category, your lordship. We are the manufacturers.
all the petitioners
All
are
the
in the first category.
Yes. The first two petitioners are Prabhat Fertilizers and petitioner number 3 is MD Biocode for weedicides and pesticides. We were eligible under the tender conditions, your lordship. Thereafter, your lordship would kindly come to page 102, where a corrigendum was issued. Page 102, your lordship.
It is after the bids were submitted or prior to bid?
Prior to the bids being submitted.
Page 102.
102. 102 is where the corrigendum starts.
Yes.
The relevant portion for your lordship's note is at page 103. At 103.
19/10/23. 103.
103, your lordship. Which is sought to amend the clause 4.2.1.
Okay,
Yes. If I may read the amended language. Your
sought
lordship.
to amend. Why do you say sought to amend? It has not amended, you mean?
It has not been amended because there's an interim protection which has enabled the petitioners to participate.
No, so this has amended it.
It's amended effectively.
Don't say
for
sought
us.
to amend.
Yes,
When you say
yes,
sought to amend means
yes.
they're seeking to amend.
Seeking to amend in our case.
Yeah, out here it's amended.
It's
basically.
amended. It's amended.
Then it's amended.
Yes.
Amendment of
Clause
2.5.
4.2.1.
2 point
4.2.1
4.2.1.
in the NI.
Okay.
Yes.
Is an amendment of what?
Of clause 4.2.1. 4.2.1 in the NIT has been amended by the language on the right column, your lordship.
But what was earlier it was this.
Earlier, the language existed as is on the left column, your lordship.
And also should have experience of manufacturing the quoted items of not less than 3 quantities
In fact, the first paragraph is still fine with us. The offending portion is the second paragraph that starts at page 103, Your Lordship. Manufacturer should also have an experience in supplying of at least 30% quantity of quoted items to any government departments / undertakings / entities / PSUs within the last 5 financial years, that is 2018 to 19, 19 to 20, 20 to 21, 21 to 22, and 22 to 23.
So experience is required in both.
Yes, experience is required in both.
Yes, so if you have had the experience
Yes.
of supplying earlier,
Yes.
why don't you have why don't you have the experience of supplying 30% of the quantity?
The issue here is that we have the experience of supplying, but there is a rider here. If your lordship sees that there is a rider to supply, the experience is in terms of government entities.
Government
Now,
agency.
that is the issue that we are facing in this
Okay, it's
matter.
not the 30%, it's
It's
the
not
government
30%.
agency.
In fact, we have
Government
supply
departments undertaking entities.
Yes.
Oh,
Yes. In that regard, your lordship had raised the query. If any of our suppliers had distributors and suppliers, and they participated and that made the cut under the technical assessment. In that regard, your lordship has been furnished with 2 copies of instructions that we've received from the petitioners, where MD Biocoal, who is the petitioner in the 3rd writ petition, 6591.
Yes.
There, in 65.
Yes, Biocoal,
Yes, their authorized supplier has made the cut.
authorized supplier maker.
Yes. Take business. Now, our issue.
Their authorized supplier or distributor?
Supplier. Because when a supplier or distributor, when they participate in the bid, the idea is that they have to seek an authorization letter from the original equipment or the original manufacturer. And that is how we understand that one of our suppliers, whether they participated or not. So Take Business, who is an authorized supplier of MD Biocoal, they've made the cut under weedicides and pesticides. They have been technically made responsive.
So, okay, yes, so that only for Biocoal. What about you?
For Prabhat
What about 1 and 2?
Prabhat Fertilizers. Yes, 1 and 2 is Prabhat Fertilizers. Even we satisfy the supply criteria which has been laid down, except for the stipulation of having supplied to government entities. That is the only offending clause that we have. The primary reason being that we as manufacturers, our first line of contact is not with the ultimate customer or the consumer. It is for us to sell our products to an intermediate level, your lordship, which is either a distributor or a retailer or an importer, depending upon the fact that if my goods go to a separate country. It is a pertinent stipulation for a distributor, for a supplier, in my humble submission, to have that criteria laid down in the NIT. But for a manufacturer, as to where and how their eventual commodities reach is not in the hands of the manufacturer. It is in the hand of the intermediary who actually sells it to the other, to the end customer. And we have the petitioners have all the criteria, all the supply experience that is required, except for the fact that the supply of government to government undertakings and state has been stipulated. That is the only offending clause in the entire NIT, taking into account.
So what is your case?
Yes.
Any citations? What is your?
Yes.
What is your supporting argument?
Yes. Dr. kindly. The list of books have been provided in your lordship.
How many books?
3 small judgments, your lordship, ancillary and essential conditions.
Ancillary and
Essential conditions. Whether it is essential or ancillary for a manufacturer to have a certain stipulation of supplying to the government. That is the only point that we are on in this matter, your lordship. Because the lordship had raised the query as to whether if our supplier or distributor makes the cut, it entirely makes the entire stipulation redundant. In fact, the stipulation which has been added by the government by way of a corrigendum is based on the standard bidding document which they have appended. And the standard bidding document nowhere stipulates that there has to be a supply experience to the government entities. The experience of supply to a government entity is an improved
Corrigendum made on the basis of
standard bidding document, which is my learned senior friend's document.
by the agriculture department.
No, the books are there. It was confirmed. Citation bit of, 2006.
Have you given any list?
Yes, on last occasion, we have. given,
How many?
Lordship, 4, 6.
My God, what is?
No, basically on the eligibility condition, Lordship.
Don't give too much on the same points. One citation is
Lordship,
enough
after
for one
repeatedly
point.
going only 2 or 3, Lordship, which covers the all cycles.
Then why do you give 6?
Lordship, I have given it, but Lordship, I will rely upon only 2 or 3, Lordship.
And please take away the others. You're burdening us unnecessarily. I mean, if you're going to rely on all of them, it's okay. But if you're going to rely on 2 or 3, so please don't burden us with 6 books. Anna. Yes.
Yes. The lordship kindly takes up the affidavit filed by the state, where the basis for introduction of that language has been stated.
Yes.
Your lordship, at page 123. Page 123 of the affidavit. Paragraph number C.
Yes.
This is the only explanation for incorporation of the amended terms as has been laid down in the affidavit filed by my learned senior friend, your lordship, that the deponent states at the time of issuance of the e-procurement notice dated 29/9/2023 under memo number so and so inviting from eligible bidders for supply of micronutrients and agricultural line for the year 23-24. The experience of supply of the quoted items by the manufacturer in the eligibility criteria of the tender document
As provided under.
the SBD was inadvertently omitted. The said unintentional omission and other aspects suggestion on coming to the notice of the department. The department bid committee upon deliberation amongst other modified the eligibility criteria of the manufacturer. Accordingly, in terms of the tender conditions, the corrigendum 1 dated 1910 was issued. That is the first leg of explanation of the incorporation of the term. Now your lordship will kindly come to page 141. 141 is the standard bidding document. 141 is a standard bidding document.
Yes, I've got it.
Now your relevant portion is at page 144. At page 144.
Yes.
4.2.1.
4.2.1.
1 subclause 2. Clause 1 is not for the petitioners. Clause 2, your lordship says that the manufacturer.
Yes.
The manufacturer of the quoted goods should have valid manufacturing license and an experience of manufacturing and supply of at least for 3 financial years ending on 31st March 2021. This is fine with us. They want a supply experience. We have a supply experience. Now, their very assumption and submission that the incorporated language was introduced on the basis of the standard bidding document. The standard bidding document prescribes this language. The manufacturers have no dispute with this language in the SBD. What now they have done
is that they've improved upon to further provide a stipulation that the supply has to be in terms of government entities.
So they are the author of their own
The author,
tender, that's what they're going to say.
that's what I'm gonna say. And the author of the document is not the NIT, but the author is of the SBD. Since the SBD has been invoked in the document, the authoring of not this NIT, but the authoring of the SBD has to be looked into account by your lordship.
So what is the citation that you're going to rely upon?
Yes. 2016-12 SCC. 2016-12 SCC, your lordship.
Yes,
Yes, page 632.
yes.
The relevant portion is at paragraph 10, 11, and 12.
Yes.
Your lordship, wants me to read it, I'll read the portion, your lordship.
Oh, okay. He's hungry. Sorry.
Not, this is PK Deka was contacted and he has agreed.
PK Deka.
This is PK Deka. Prashant Deka.
Okay, PK Deka. Huh? Okay, very good.
That's it.
So I think, yeah, main problem solved.
Yes, so let us hope. But secondary problem remains. We'll come back after 6 months. So let us see the lot, but if the amount is small,
Ah.
then possibly there would be no litigation further.
If the amount is small, you'll keep quiet. If the amount is big,
You
then.
will come over here,
then-
raising legal questions.
My lord, item number 13, because your lordship has fixed some other method than 2 PM, my lord, probably item number 13 is because otherwise item number 13 was fixed today for consideration of interim order. My lord, other side is also there. May I pray that it may be taken up on the next Thursday, my lord.
I have already filed my affidavit. My learned friend
Today
doesn't want
we
to
have
file any
filed.
reply. It can be taken up for final disposal.
On Thursday, coming Thursday, my lord.
We have got, I don't know, everything is a risk and we can fix, but we have fixed all, I mean, today also, I don't know whether we
Yes, my
can.
lord, I understand. That's why I'm just mentioning. On Thursday, my lord, we will take a side, my lord.
The week after that,
No, my lord. Because, my lord, it is a tender matter, my lord. IMFL shop, my lord, and there was a direction for consideration of interim order after service of justice service notice on the private respondent. That has been.
What are you praying for?
I'm praying for, my lord.
Issuance of the license.
Yes, my lord.
In
No,
your-
no, my lord. My bid has been improperly rejected at the technical bid itself. And he's at the bid.
He's
of-
running the shop.
No.
I've already got the license, my lord. I've
He has
deposited
got
my
the
bid well.
license.
What the primary contention is when he went to deposit his, submit his hard copy, there was no designated box.
Wow.
Now, what we say is he went to submit it after the last date of submission, and that is why it was rejected. Anyway, I have filed my affidavit in opposition. He doesn't want to file any reply to that. Your lordship will fix it for final disposal, my lord.
On coming Thursday, my lord.
Okay, item 13, you just say, Mr. DP Bora and Mr.
AK Burwa for respondent number 4.
AK
And my
Barwa.
learned friend is for excise.
Acha DP Barwa for petitioner, Mr. AK Senso and Mr. KP Pathak for counsel for the respondent submit that they have got no, they submit that pleadings are complete. According.
Yet to file.
Oh.
Yeah, file.
Are you filing?
We will file in the course of the day.
Okay, then just say Mr. DP Bora and Mr.
AK Burwa.
AK Barwa, counsel for the private respondent submit that they will not be filing any further affidavit. Mr. KP Pathak, counsel for the excise, submits that he will be filing affidavit
During the course of the day.
within the course of the day. Accordingly, list this matter on
15/5.
22nd.
15.
Vice Chancellor.
Can it be on 20th, my lord?
20th, okay, 20th.
My lord, on last occasion, your lordship was pleased to fix on a hearing date, my lord.
Okay.
For disposal. So can it be on 21st, my lord?
28th is March, February, look
Yes,
at
my
February.
lord. I was looking at the 2023 calendar, my lord. Obliged, my lord. Deeply obliged.
Yes, yes. Yes.
Yes, Your Lordship, the corrigendum which introduced the offending clause, the corrigendum was dated 19/10/23. That's the date of the corrigendum, which is at Annexure C,
19, corrigendum dated?
19/10/23.
Yes.
Yes.
So,
Now, Your Lordship will kindly come to page 108,
108.
which is the minutes of the departmental bid committee of the meeting which was held prior to that. 108. Your Lordship sees that 108 Annexure F.
Yes.
Minutes of the departmental bid committee meeting held on 16th of October 2023 on issues, suggestions received from the bidder on e-bid of micronutrients and agricultural line for the year 2023-24. Now, Your Lordship, the relevant portion of the change which has been carried out is at page 111. Page
No,
111.
no, what do you want to show, which is 108?
Yes, the reason which had been stated that the change was incorporated due to bidders' issues / suggestions on the clause.
Where?
Your Lordship will kindly come to page 110. 110, Your Lordship.
Okay, 110.
Your Lordship sees this, the first column is serial number, the second clause is bid clause.
Yes.
The third column is bidders'
Issue.
suggestions on the issue.
Yes.
Now, Your Lordship will kindly come to the next page, 111.
Yes.
The bidder, within bracket, if not the manufacturer of the goods offered should have experience in supplying of goods similar in nature within the schedule of requirement of at least 30%.
20%.
30%. The 30% is at 112. Page 111, Your Lordship.
111. Yes, I've got 111.
Yes. The last block.
The word average.
Below that, Your Lordship. The last more.
Bidder should have experience.
Yes. I apologize, Your Lordship. Yes. The bidder, if not the manufacturer of the goods offered, should have experience in supplying of goods similar in nature with the schedule of
Well,
requirement.
it says bidder should have experience.
Yes.
Where does it say if not the manufacturer?
Yes.
Where does it say if not the manufacturer? It does not say here.
It says that.
Not in my copy.
It's, Your Lordship is taken up 6588.
You mean the middle column?
No, not the middle. This column.
Okay, the bottom.
The bottom
Okay,
column,
okay.
Yes.
Yes.
The bidder, within bracket, if not the manufacturer of the goods offered, bracket close, should have experience in supplying of goods similar in nature within the schedule of requirement, within bracket, that is micronutrients or agricultural line. I'm the next page. Of at least 30% quantity as specified against a particular item.
But then this only speaks of
Yes.
micronutrients and agricultural line.
This
That-
is yes.
It doesn't speak of weedicides and pesticides.
Yes, the reason being, Your Lordship, the respective writ petitions, the departmental bid committee meeting, in terms of the 3 writ petitions, the 3 items, quoted items, had taken place on the same day. And the suggestions are almost identical, subject to a few correct changes. So if Your Lordship takes up 659989, Your Lordship will find a separate departmental committee evaluation with my news. Your Lordship takes up.
In 6589,
Yes.
page,
Yes, 6589. 6589, Your Lordship, is that starts at page 110.
yes.
Yes.
Where is the relevant page?
Yes.
What is this, that thing, that paper?
The relevant page is page 112.
12.
Yes, 112.
Yes.
That
Yes.
is where the change is taking place.
Huh?
That is where the departmental committee, bid committee meeting in terms
Where
of
is that? Where is that?
112, Your Lordship.
Yes, I've got it. Which column?
The last column on the right. The last column on the right.
Yeah.
Supply experience of manufacturer is to be 30% quantity of quoted items.
How does it start? The sentence in column, in serial number 2?
Serial number, not serial number 2. It starts at serial number. Just, Your Lordship, here. It starts at serial
114 the page number.
112, page 3, sub-point 3.
Hmm?
Experience of manufacturer at
That is 114, not 112.
It's 112. Right?
At least in my copy, it's 114. How does it read?
Yes. It's 6591. I've taken up the wrong repetition. Yes. Yes. Yes, 114.
Yes.
Manufacturer, experience of manufacturer.
Yes.
The third column, if I may go into read.
Yes.
If the manufacturer is participating in the bid, in the case of manufacturer should have valid manufacturing license of the quoted items and should also have experience of manufacturing the quoted items of not less than 3 times and 100% supply experience to any government, department, undertaking, entities, PSUs, quantity as specified for each item in the bid document. In fact, this column, your lordship.
No, where? Acha.
Here, this column is a suggestion.
No. Where is this?
114.
114. The second column, you mean, or the third column? Which
This
one?
column, the first.
Okay, the first column, yes.
Yes.
Okay.
This column deals with bidders, suggestions, and issues.
Yes.
The amended language is on the last column, your lordship.
Yes.
So a similar exercise has been done in terms of all the writ petitions, in terms of all the quoted items, that the supply experience of 30% has been prescribed for manufacturers.
Yes.
Yes, that is the amended clause.
So?
Yes. The document here, your lordship, which is the annexure F at all the writ petitions, it states that the reason for incorporation.
You see, in this, the first writ petition,
Yes.
out here it has been clearly stipulated.
Yes.
The bidder, if not the manufacturer.
Yes.
So manufacturer is out. In the first writ petition at page 111,
Yes.
the manufacturer is wide experience.
Yes.
Correct?
Yes.
But not in the case of this other writ petition. In 6589, it's not there.
Yes.
There's a difference.
There's a difference, and in fact, the
So this one is against you.
this one is against us. There are the 3 classes which have been earmarked.
But out here, again, the standard bidding document is in use.
So what has happened is when the changes took place, they relied on apparent suggestions of the bidders and issues. Thereafter, in the affidavit which has been filed by my learned senior for the government, the reliance of the change of the incorporated language was based to be the standard bidding document.
Good enough.
And the standard bidding
Does
document
not contain the clause.
does not contain the clause of supply to a government entity. It says supply of. a
Okay,
supply
that condition is not there.
That condition we have.
So
And-
why do you want to go into this? In this writ
No,
petition?
I just wanted to lay your lordship's attention to the fact that there have been 2 subsequent stands taken by the government. In fact, if the standard bidding document was a model document which was to be followed, it was imperative that the conditions laid down in the SBD.
So stick to that.
Yes.
Okay, for the first writ petition, you can rely upon this.
Yes. So in fact, what has happened, if your lordship kindly comes to the affidavit which has been filed.
Now, what about the third writ petition, 6591?
6591, yes.
Experience of bidder, 110.
It's at 112.
112.
Experience of manufacturer.
No, come to 110.
Yes. Experience of bidder other than the manufacturer.
This will not come.
No, this will not affect us because there have been 3 classifications of bidders in the NIT. There are manufacturers, there are distributors, and there are importers and dealers. So your lordship is looking at experience of bidder within bracket other than the manufacturer.
Yeah.
That pertains to a different class of bidders, which I'm not affected by. I am affected primarily by the changes to the clause of manufacturer.
No, because out here, it
Yes.
says the bidder, if not the manufacturer,
Yes.
should have experience in supplying of goods similar in nature,
Yes.
that is chemical, pesticides,
Yes.
and weedicides.
Yes.
So,
Yes.
isn't this in your favor?
No, this is in my favor, but the thing is, your lordship, this clause will affect other classes of bidders. Like distributors, importers, retailers, sellers.
So-
This change does not pertain to my standing as a manufacturer. I am affected by the change which has been carried out at page 112.
Okay.
Yes.
So what is the reason given by them? Forget the affidavit.
Yes.
What is the reason given by them for putting this corrigendum?
To put the spirit of the standard bidding document in place.
Where have they said that?
Yes, yes.
Have they said that in the meeting minutes?
No, that is what I wanted to get your lordship's attention to, that they had deviated from the minutes which have been appended.
In the minutes, what was the reason for them?
Bidders, issues / suggestions.
Huh.
There cannot be a manufacturer's suggestion to make the terms more onerous for my class, assuming it were to be true. But they eventually, in the affidavit, they relied on the standard bidding document. If you're not,
Let us see the meeting minutes again. 6588.
6588.
Page 108.
Page 108. If I am permitted to read it.
Yes.
Yes. The departmental bid committee meeting was held on 16th October 2023 to discuss and finalize on issues / suggestions received from bidder in writing on e-bid of micronutrients and agricultural line bid reference number so-and-so dated 29/9/2023. Three so-and-so CIS and chairman bid evaluation committee gave a detailed presentation on issues / suggestions received from bidders in writing on e-bid of micronutrients and agricultural line bid reference number so-and-so dated 29/9/2023 for the year 2023-24. Shri so-and-so CIS and chairman bid evaluation committee informed the house that a pre-bid meeting on e-bid of micronutrients and agricultural line was held on 7/10/2023, which was attended by aspiring representatives of manufacturing companies / dealers / suppliers, along with bid evaluation committee members. Shri so-and-so informed that during the pre-bid meeting, issues / suggestions raised by the representatives of the companies / dealers / suppliers, both verbally as well as in writing, were discussed and documented. Shri so-and-so also informed that the issues / suggestions were also received from a bidder after pre-bid meeting in writing and written petition received from the bidder up to 9/10/2023 till 5 p.m. During the departmental bid committee meeting, a detailed discussion was held on the issues / suggestions raised by the bidder in writing. The major issues raised by the bidder in writing were average annual turnover, experience of bidder including the manufacturer, minimum quantity to quote, latest date of test report, extension of date of online bid submission, extension of date of submission of hard copy of bid, etc. The issues / suggestions raised by bidder in writing and decision of DBC on respective issues and suggestions are enclosed in Annexure 1. During the meeting, it was decided that corrigendum will be issued incorporating the changes made in the terms and conditions of the bid as per agreed issues / suggestions received from the bidder, which should be published in Assam government e-procurement portal, that is so-and-so at the earliest. So the reason here, your lordship, most respectfully state, the reason here has been stated to be suggestions coming from the bidders, which has been subsequently bypassed onto the standard bidding document as a result for carrying out the incorporated changes.
Anyway, this meeting minutes at 108 only relates to micronutrients and agricultural line.
Yes.
It does not relate to that weedicides and
The other
pesticides
petitions have an identical copy on.
of that,
Yes.
on
Yes.
that.
The contents are
Same.
except for the specifics. Yes, Your Lordship.
So basically, it was on the basis of the meeting that they changed this thing. Without specifying that they are applying the condition in the standard bidding document.
And the standard bidding document.
Does not contain that
And
condition.
there is an inherent wisdom in the standard bidding document, in as much as the standard bidding document foresaw the roles that a manufacturer plays vis-a-vis against a dealer and a supplier or an importer.
So that's why it was not there.
That is the reason why I submit before this court, Your Lordship, that the submission if it was based on the SBD, would have not.
Would have not barred
discriminated-
you.
Would have not barred us. If the SBD was taken and imported as is, because there was some wisdom in the SBD and the way it was drafted, because it saw what a manufacturer does. Tomorrow, if my manufactured goods go to a private entity or a government entity, that is not on me to decide as to who the end customer is. In fact, the entire terms and conditions, along with the conditions laid down for manufacturers, they lay down very stringent financial terms also. And if my only condition here and my only grievance here is with regard to only one condition, that means that I am a genuine manufacturer. I have supplied.
Okay, anything else? What is the citation? No time now.
No, citation, we have citations about it.
I think these three books,
Yes, yes, yes.
one is this,
2016,
12,
12 SCC, 632.
yes,
Om
para
Prakash,
10 to 12.
Para 10 to 12. The differences with regard to essential and ancillary conditions. And there's another chain of submission that might flow from this.
So according to you, it's an ancillary condition.
Because non-compliance of that condition would not prejudice the government as a customer of the agricultural products. Non-compliance,
But it is a condition nonetheless.
the condition is 30% supply to the government entities. Whether I supply to the government entities or not, if that condition is not applied with, that is what has been stated here. Also, the non-compliance of a condition will determine whether it is
Yeah, maybe you are going about it the wrong way. I think. Anyway, you see, because as it is, the government is the author of the tender.
the government is the
Then-
author of the SBD. The SBD was relied. Now the book which has been authored.
So what should
cannot-
be a citation in that regard?
So there's no case law specifically relating to whether the authored document is the SBD or the NIT, but my submission here is since they're relying on the SBD to incorporate a condition from the SBD. The SBD is the document which has been authored.
And since SBD doesn't have that
Doesn't-
condition,
Yes,
and purportedly as the corrigendum has been made,
yes,
um, on the lines of the SBD.
yes.
Then the SBD would have to be, the effect of that would be that the selection should continue on the basis of the terms and conditions laid down in the SBD. And if it was not there, how could they have incorporated that subsequently?
That is- that is not-
Madan Mohan Sharma, I think. I think that's the case. Yes, that's all. Any other thing?
Small citations, Galaxy.
Huh?
Galaxy Transport and Afcons.
Sorry. What is this? Afcons again, the para 15.
Yes, and 16. And Galaxy Transport, which talks about Afcons here also.
But then, no, how does Afcons help you?
Yes. Yes. We may add that the owner or the employer of a project having authored the tender documents is the best person to understand and appreciate its requirement and interpret its documents. The constitutional courts must defer to this understanding and appreciation of the tender documents unless there is a malafide or perversity in the understanding or appreciation or in the application of the terms of the tender conditions. It is possible that the owner or the employer of a project may give an interpretation of the tender documents that is not acceptable to the constitutional courts, but by that itself is not a reason for interfering with the interpretation given.
How does this help you?
This, Your Lordship. There's a malafide and the perversity that has been stated in paragraph 15, Your Lordship. Is the fact that incorporation that
I don't think this helps you. Anyway, next.
says Galaxy Transport, Your Lordship.
Where is that?
2021 16 SCC.
Para page?
Yes. Page 14, paragraph 14 onwards, Your Lordship. In fact, it talks about the interpretation that is to be given to a tender document and who is the,
Para 14.
yes, para 14 onwards, Your Lordship. In fact, paragraph 16, which quotes Shilpi Constructions Contractors versus Union of India. Paragraph 16, Your Lordship. Kindly.
16.
Further, in the recent judgment in Shilpi Constructions Contractors versus Union of India, this court held as follows. The essence of the law laid down in the judgments referred to above is the exercise of restraint and caution, the need for overwhelming public interest to justify judicial intervention in matters of contract involving the state instrumentalities. The court should give way to the opinion of the experts unless the decision is totally arbitrary or unreasonable.
You see, out here, it's not a question of interpretation. Out here, it's a question of whether the condition subsequently put, whether that can be allowed to remain. So that's slightly different. It's not a question of interpretation.
It's the interpretation of the SBD, Your Lordship.
Huh?
The interpretation of the Central Bill.
The interpretation of the SBD, yes, basically, you see, once I think once an advertisement has been made on the basis of a circular, then that selection has to be made on the basis of that circular. Now the problem is here, the circular does not say, the circular is the SBD, assuming. Now see, the circular does not bar you. However, they have barred you. So now the issue is whether the application or the interpretation of that circular is correct or
That is
incorrect.
the question that falls.
Because the interpretation of the SBD does not provide for barring you.
Yes. Does not.
I think that's the only way to look at it.
That's the only.
Or from your point of view.
In fact, Your Lordship had also raised a very pertinent query that whether our suppliers have made the cut or not. Is a submission that, in fact, under the petition for pesticide and pesticide, one of the suppliers of one of the petitioners have been made technically responsible.
Who is this?
Tech business.
Huh?
Tech business.
How do you spell?
TECH. Business.
Tech business.
Yes.
Address?
The tech business is at VIP Road.
VIP Road?
Yes. 6 Mile.
VIP Road, 6 Mile?
Yes.
6 or 6?
6.
6 Mile?
Yes.
Guwahati.
In fact, the Lordship had sought instructions on the 1st of February hearing the matter, and instructions were furnished before Your Lordship.
Okay, yeah. I think that's all. Have you checked out the judgment? Madan Mohan Sharma, I think.
Criminal case.
Huh?
Some criminal case.
The state of Rajasthan. State of Rajasthan. Anyway, I'll check up.
I'll have to take a minute.
What is the citation?
Madan Mohan Sharma versus State of Rajasthan, 22nd of February 2008.
I'll find out one. The judgment I have got matter, but in another site, not on that secure. I'm trying to find.
Okay, yes.
Lordship, Lordship has seen the corrigendum and the insertion of the new condition.
So basically, your case is that the corrigendum has been incorporated in terms of the SBD, correct?
Lordship, suggestion from the prospective bidders in the pre-bid meeting.
What have you said in your affidavit?
Yes, ma'am.
Let us not go, let's make it simple.
Yes.
That way.
Lordship, page 122, paragraph 4B, Lordship, may copy. Lordship, that SBD was issued in terms of the Assam Procurement Act, which directs for issuance of an SBT. Standard bidding norm, Lordship, I may read it. The deponent states that section 20 subsection 4 of the Act 2007 provides the state government may prescribe model bidding document for different classes of procurement.
Come straight to 123.
Yes, sir.
123 C, para C.
Yeah. That the deponent states at the time of issuance of the e-procurement dated 29/9/2023 under memo so and so, inviting from eligible bidders for supply of micronutrients and agricultural lime for the year 2023-24. The experience of supply of the quoted item by the manufacturer in the eligibility criteria of the tender document as provided under SBT was inadvertently omitted. The said unintentional omission and other aspects suggestion on coming to the notice of the department bid committee upon deliberation among others modified the eligibility criteria of the manufacturer. Accordingly, in terms of tender condition, the corrigendum dated 19/10/2023 was issued.
So it's basically because of the SBT.
SBT, Lordship. And the purpose of giving the supply condition to the government, Lordship, that will be reflected in 4E, the last paragraph of that page, 124. D also, Lordship, in SBD clause 4.2.12 under the heading required minimum experience, the manufacturer of the quoted goods should have valid manufacturing license and experience of manufacturing and supplying of at least for 3 financial years ending on 31st March. However, the Directorate of Agriculture Assam, White Corrigendum dated 19/10/23, the period of supply experience was relaxed up to last 5 years, that is so and so year, so that more and more bidders can participate in the bidding process. As regard the insertion of requirement of supply experience for the manufacturer of the quoted good, the clause 4.2.1 required minimum experience of the SBD may be read in its entirety. The bidder, open bracket, if not the manufacturer of the goods offered, close bracket, should have experience of supplying goods of similar in nature it is bidding for to different government department undertakings, entities or quantity as specified below during the last 3 financial years. Here, Lordship, other than the manufacturers, must have an experience of supply to the government departments or a public sector undertakings. But in subclause 4.2.1, Lordship, the manufacturer of the quoted goods should have valid manufacturing license and an experience of manufacturing and supplying of at least for 3 financial years ending on 31st March.
Supplying to whom?
Lordship, in the manufacturing part, no supply experience was given.
No. Supply
In general, it was
supply experience was there. But
general,
there was no supply experience required to be given to
specific
to the government.
Yes, my God. But Lordship, if
Because you see, manufacturers, unless they supply, there's no question of
but
being
Lordship,
able to sell their
Lordship,
materials.
that clause, Lordship, will see that the bidder, other than the manufacturers, they are required to have supply experience to government. Whereas the manufacturer, it was not given. So, in the spirit of that clause, 4.2, Lordship, the supply experience to government.
But what is the logic? You see, because the SBD does not provide for manufacturers supplying to the government. Manufacturers usually just supply to the distributors and stockists and whatever. There is no requirement of supplying to the government because the government is being supplied by the distributors. Now here, a piquant situation has arrived with regard to WPC 6591. In 6591, the manufacturer does not have that eligibility of supplying to the government for 3 years. However, his distributor, his authorized dealer, he has got. So his authorized dealer can take part, but manufacturer cannot take part.
But Lordship,
Now I am making this pen. I am making this pen. You are my supplier. Because you have been supplying to the government for 3 years, you are eligible to participate with my pen. You can supply my pen to them. But I, the manufacturer, cannot supply because I have never supplied to the government. Is it logical?
but the tender documents, Lordship, clearly provides that if the manufacturer participate, then there is no requirement of the supplier or dealer to come forward.
But where is the
He is
Mr. Council?
participating.
No, no,
Lordship.
no. There's no requirement for the dealer to participate. That's what you say. But where is the bar for a dealer and a manufacturer both to participate? Is there a bar? If I am the manufacturer, you are the dealer. If you want to participate and I want to participate, can the government say no? Only one of you should participate.
Because the dealer, Lordship, he may not be a dealer of that particular manufacturer only. He may be dealer of another manufacturer also. So
Correct.
he has to give the authorization. The manufacturer has to give the authorization letter. So in that case, the manufacturer can't take benefit from both sides, Lordship. As a manufacturer also, he can participate. Through his
You
supplier
see,
also, he is
no,
participating. That is barred.
You see, the government, if they take it directly from the manufacturer, they're going to pay less. When you buy through an authorized dealer, you're going to pay more because dealers' profit margin is there also. That commission is there. There is one aspect what you have said is correct, that he might not supply my goods. He might be supplying other goods.
Yes.
But then he might supply my goods also. How do you know? Where is the bar?
But that if he is representing or supplying a particular product of a particular manufacturer, that authorization letter he has to give in the bidding document.
Yes, there is one question. Now you see, according to him, that in this Biocoal Private Limited, Biocoal Private Limited is a manufacturer. His authorized dealer is allowed to take part in the bidding process because he's got 3 years experience of supplying to the government. Now what he says is that maybe that dealer has got the eligibility, but he might not supply the materials that Biocoal makes. How do we, how do you?
Now, my lord, one thing I need to clarify, my lord. When a dealer participates in the tender process,
He will have his dealership certificate.
he will have a authorization letter from us.
Ah.
And in that event, the manufacturer doesn't.
And in this case, have this person got your
In the weedicides and pesticides, my lord, the only suppliers have participated, we have not supplied.
No, I agree. So the question is, when this tech, what is this?
Yes,
Tech business.
Tech business, when he took part, when tech business took part in the bidding process, whose dealership certificate did he submit?
My lord, that instruction we have given, MD Biocoal.
Yes.
Yes.
So you, okay, then. So now this is a question of fact. We do not know. Supposing now what they say is correct, that will be known only at the time of opening the tender. So in that case, let them participate. Supposing the business tech business, which is a dealer for Biocoal, they have used Biocoal's, they have said that they are Biocoal's tender dealer. Then in that case, there is no justification for denying them, the manufacturer. Correct? So now the problem is now you cannot open the tender and see whether they are dealers of Biocoal.
Lordship, one thing I would like to point out, technical evaluation was completed.
Okay.
And that was placed before you.
Oh, that is there. Okay.
And secondly, the financial bid evaluation has also been done as per court's
Okay.
order, but only in respect of those items where the petitioners have participated. Those
Have not been done.
allotment order has not been given.
But it has been opened. Everyone is there.
Otherwise, the other items, Lordship, where there is no issue, Lordship, allotment order has been.
No, but all the tenders have been opened.
Yes, Lordship.
They have not been allowed to participate, that's all.
No,
Correct?
they have participated.
Participated.
As per the interim order.
Okay,
of
then
this-
let us see. Then be very easy. Then if Tech Business has been allowed, has submitted his dealership certificate as an authorized dealer of Biocoal, then they should be allowed. Simple.
Lordship, that financial bit that was kept in sync cover.
Okay.
Lordship. Then Lordship, that.
Well, there is this judgment where you see, once advertisements have been issued on the basis of a circular, then the selection has to be done on the basis of the circular. So what I'm trying to say is, since they are saying that the advertisement there's been a correction to the advertisement in terms of the corrigendum, keeping in view the SBD, then the conditions in the SBD are trying to be incorporated into the advertisement. As such, the terms in the SBD would have to be considered as this. Now, when there is nothing to that effect in the SBD, can they apply a term which has no basis for being incorporated therein? So now that's why I want the judgment. There is a judgment. There is a judgment of the Supreme Court that says that once an advertisement has been issued on the basis of a circular operating at that relevant point of time, the selection has to be made. It may be a service matter, it may be a contract matter, I don't remember. Huh?
The Uttar Pradesh versus Pune tomatoes.
Citation?
This one is Lordship. It's Lordship AR 2023 SC 52 Lordship.
Yeah.
AR 2023 SC 52 Lordship.
Para?
Para probably Lordship para 32 Lordship. 32.
Anyway, just look at it. This is the thing. This Biocoal took part in Tech Business. Okay, Tech Business. Tech Business is here.
Tech Business, your lordship must have found at serial number 13, correct?
Tech Business, number 13, accepted, technical, qualified. So it's accepted. Now, but then we don't have their thing, their tender document to show what are the documents they submitted. Whether they submitted their bid as your dealer.
Before that, my lord, we had got that instruction in writing, my lord. We have placed with your lordship.
Where?
2 pages mail, my lord.
Which one? This minute or no, this is the original.
Single pages we had given.
When did you give? Yes.
On the 3rd of February, the matter was heard.
I don't want to mix it up. Yeah.
Or I can give the copies that
Biotech, Tech Business has been thing.
May I give it?
Yes. Yes. Is how Mr. Gogoi is he or no? Achha, there. No, I want, that is all right, but I want to know what they submitted before the authorities.
That only we can.
That is why. That is the thing.
It is Mahendra Singh, paragraph 14.
Paragraph 40.
Sorry, Vinegar 14 weeks.
You can give him a slap on the head. Why you?
Lordship, that I intend to do.
He has become an encyclopedia now.
Oh,
Mr.
Mr. Gogoi.
Yeah.
Must be. No, this is slightly different. No. That is where thing has to be done in a particular manner. It has to be done in the. No, that is different. Yeah.
For advertisement, they can.
Okay.
Advertisement also. As per the advertisement.
It is a slightly different context. Anyway, I'll have to look for the judgment. It is with regard to yes.
Your Lordship, that Mahendra Mohan Sharma,
हाँ.
that case has given, your Lordship may kindly peruse paragraph 11. That may have some relevance.
Which one?
Mahendra Mohan Sharma is that your Lordship law versus state of Rajasthan.
हाँ.
That paragraph 11
हाँ.
may be relevant.
हाँ.
Or here she has not been able to get the point.
What does
May
it say?
I just read
Yes,
that?
yes.
We have heard so and so, peruse the records. Senior counsel appearing for the appellant has strenuously argued that during the pendency of the selection process, the eligibility criteria were changed and the date for submission of the application in pursuant to the advertisement was extended. And Rule 226 of the Rules 1996 came into being on 30/12/1996, whereby it was provided that the higher secondary examination shall be the criteria for preparing the merit list. As such, as per the service rules, the selection should have been made on the basis of the higher secondary examination mark and not on the basis of the secondary examination mark. We regret this cannot be accepted. Once the advertisement has been issued on the basis of the circular, obtaining as.
That's what I'm saying. That's what I'm saying.
Yes,
Yes.
At that particular time, the effect will be that the selection process should continue on the basis of the criteria which were laid down, and it cannot be on the basis of the criteria which has been made subsequent. Your Lordship is right.
That is Madan Mohan Sharma.
Madan Mohan Sharma.
Just give me that citation. Just print it out.
2008, Volume 3, SCC, 724.
Please, what is my ID? I have no idea. My email, you know? No. M. Zohan Kumar.
2008, Volume 3, SCC, 724.
It's not exactly to the point, but I mean, I think it can be applied
This
here
principle
somehow.
can be applied, my lord, although this is
The
a service
principle.
matter, but then my lord, the principle can be applied.
But I'm on a slightly more different footing. Though the corrigendum can be a subsequent criteria that has been put in. But in this case, the basis for the corrigendum was the SBD,
And
but the SBD itself does not have that. So initially also it did not have. The corrigendum which has been made on the basis of the SBD, which also does not have the condition. So can a condition that never exists,
Yes, that can be put.
either in the advertisement or in the basis for putting the corrigendum, can that now be applied? That is what I'm trying to say. Correct?
Your Lordship is right, absolutely.
The corrigendum provides that experience for supply to government should be there. The initial NIT did not have it. the corrigendum requiring that condition has been put due to the SBD as per the affidavit. But the SBD itself doesn't have that condition. So can a condition that never existed in the circular which you are seeking to incorporate and which you had missed out in the tender notice, can that be applied? Can a thing that never exists be applied?
Your Lordship has
So,
formulated the issue, my
huh?
lord. Your Lordship has formulated the issue under very precisely. That is the issue.
That's the issue. I think so.
But Lordship, the clause under the SBT, on one hand, it is providing to the bidder other than the manufacturer, the supply condition to the government. And on the other hand, the manufacturer. But the whole clause has to be written in an entirety that there must be a supply. Supply. There must be a supply. And
That
Lordship, and to ascertain whether that manufacturer supply is good enough for the authorities. Lordship, it has to be the government supplying to the government. Lordship, that entire the spirit of that clause has to be taken into account. What has been incorporated in the SBT.
Let us see once more. Let us see that page 110. Yes, I'm trying to understand your argument.
They are trying to modify the SBT.
Huh?
They are trying to modify the SBT.
I don't know. Let us see. It says here, the bidder, if not the manufacturer of the offered goods, should have experience in supplying. The bidder. It says bracket, if not the manufacturer. So manufacturer is not included.
Yes, my lord, that's a separate because there are three types of bidder.
Whatever it is, three types of bidder. But remember, the SBD excludes the manufacturer from that condition. It says the bidder, if not the manufacturer, should have experience in supplying of goods similar in nature, so to any government. So the bidder, the manufacturer was never included, was never required to have that experience of supplying to the government as per the SBD. It is only in the advertisement that has been put.
For example.
In the advertisement.
No, in the advertisement also it was not there.
It's not there.
It is only in the for example.
Anyway, so that's that. So anyway, that's what I read into this. Unless you can show otherwise. Page 111 clearly says that. Experience of bidder. Other than manufacturer. Even in the column 1, it says here, other than manufacturer.
Yes, Lordship. That's the original content of the tender. And the page 113 is the experience of manufacturer.
Correct.
Particularly for
but that is on the basis of a discussion made, not on the basis of the SBD. But now in the discussion
the discussion that was made, Lordship, those discussion, Lordship, it compares with the SBD.
SBD. Now please show me in the SBD where is it required.
Lordship.
Please show me in the SBD where it's required.
Lordship, that's why I'm trying to point out, Lordship, page 144.
44. Yes.
4.2.1 required minimum experience. The bidder bracket, if not the manufacturer of the goods.
If not the manufacturer.
Yes, that other than the manufacturer.
Correct. They are manufacturers. They are manufacturers.
Yes, Lordship. But Lordship, the whole clause has to be taken into account. The spirit is that there has to be a supply experience. Whereas in the manufacturer, only
Sorry. I cannot go beyond what is written in the SBT. You cannot change the content.
I'm not trying to change the content.
It says here, supposing they say, all lawyers, bracket, if no, all lawyers bracket not the senior lawyers, what does it mean? Means all lawyers accepting the senior lawyers. Out here it says the bidder, if not the manufacturer. Means what? Bidders, but not the manufacturer. Right.
Lordship, I would like to rely upon some citations.
Oh, yes. Sure. Good. Now you are giving me homework. You told me you're going to rely only 2-3 books. Don't give me all 6 books.
Yes,
Give me only 2-3 books. You're giving me a lot of homework.
Lordship, 2004
Just a
4
minute.
SCC, that Educom case, Lordship.
Wait, huh?
Then Lordship,
Just a minute. Let me write down. Yes.
Lordship, 2004 4 SCC, page 19.
Yes.
Directorate of Education and Others.
Para.
Para, Lordship, it will be para 1, 3, and 12.
1, 3, and 12. Then?
Then, Lordship, 2020 16 SCC 489.
2020
16 SCC
16 SCC
489.
489.
Para, Lordship, 19 and 20.
19 and 20. Then next.
Lordship, 2022 5 SCC
2022 5 SCC
362.
362.
Para, Lordship, 279 24 25 26. 279.
279.
Lordship may take it up 24 25 26.
You're giving me the facts of the case.
Because similar issue were there.
Okay, 22.
24 24 25 26.
Now what was there? What is the issue in 2004 4 SCC?
Lordship, whether judicial review of the terms of tender prescribing eligibility criteria can be done. That was the issue. They were required to supply computers.
Whether judicial review.
Judicial review of the terms of tender prescribing eligibility criteria.
Cannot be done.
Yes.
Then 2020.
Paragraph 1920, Lordship, court should not use magnifying glass to scrutinize tender condition and make small mistake, a big mistake. And interference only in public interest, Lordship.
Okay, wait, magnifying glass. Then 2022.
Lordship, that if the decision is not plausible to the court, it cannot substitute its decision.
Okay. Cannot substitute decision of the experts.
Yes, basically that. And Lordship, there is a recent judgment. Lordship, I have a copy.
Hmm.
2023 SCC online SC 671 para 48 only.
Yes. Para
48, Lordship.
48. Regarding what?
Judicial review, Lordship. 2023.
What do you want to say? What the judicial review not allowed?
Lordship, following the AFCONS and CP construction, Lordship.
Judicial review of tender clause cannot be allowed. What?
When it can be allowed, Lordship, only if it is arbitrary, discriminatory, or mala fide or favoritism is there.
If it's arbitrary.
Arbitrary, discriminatory.
That's all. You have given me 4 already, huh? Tell you.
2022 SC.
So, Mr. Chakrabarti, enough?
Yep.
Thank you. I was scared you said no. Okay, right.
Lordship, one thing is there, only in respect of the items against which the petitioners participated in terms of court's order, those were kept under the seal cover in the financial date lordship, whereas the other item,
Those you give.
but those conditions with regard to the supply to the government, those they were fulfilling. Lordship, those they have been given the allotment order.
So, no, this judgment will apply only to these petitioners. Persons who have not come to court will not be able, they cannot.
Because, Lordship, in the interim order, it was given that those who have not, have got no supply experience to government, similar situated persons should be allowed to participate. And and accordingly, those have, many more have participated in the process.
Who have got no experience.
No experience.
But as long as they are manufacturers, they should be allowed.
Lordship, some of, I don't know the result of the financial bid. There were some manufacturers who were also there.
But then, okay, so you don't want them to participate.
Those issue will be there, Lordship, if Lordship.
Okay, we can put in that case of fence sitters. Fence sitters. You cannot write piggyback on the orders of similarly situated persons who have approached the court. That condition can be put. But then it will not be fair because they have participated.
In terms of the interim order, Lordship.
Okay, so those persons, okay, but okay, in those cases, tenders have already been selected, tenderers.
Lordship, other
Some of
than
them, yes.
those items,
Ah.
these items where the petitioners have participated, others,
All have been selected, no? So we won't disturb that. We'll just say that since the other manufacturers have not put a challenge to that, and since tenders have already been issued, they cannot write piggyback on the orders given in these cases. That'll take care of your case, I think.
Lordship.
But they will go in division bench or this court. Anyway, right. Heard Mr. M.K. Chaudhary, Learned Senior Counsel, for the petitioners in all the three writ petitions. All assisted by Mr. M. Sharma. Also heard Mr. B. Chaudhary, Learned Standing Counsel, Agriculture Department. And
Lordship,
nobody.
only agriculture.
Agriculture. Right. The three writ petitions have been, three writ petitions have been, are being taken up for disposal together. In as much as the issue raised by all the three writ petitioners are similar in nature. The petitioners who are manufacturers are aggrieved by the This is the word. Huh? I'll have to do it now. Otherwise, I'll have to do some parts. are agreed by
Corrigendum at page
the corrigendum -1 dated 19/10/23, comma, by which
The offending
a condition has been added to the terms and condition of the e-procurement notice dated 29/9/2023, comma, wherein manufacturers of the goods offered are to have experience in the supply of goods similar in nature of at least 30% quantity as specified against the particular item quoted. No. Should have experience. No, sorry. Manufacturer should have experience in supplying of at least 30% quantity of the quoted items to any government department slash undertaking slash entities slash PSUs within the last financial year, that is from 2018-19 to 2022-23. The stand of the petitioners is that they being the manufacturers of goods, comma, the subsequent condition of having experience in the supply of materials to government is arbitrary, as the as the first line of contact of the manufacturers is their distributors slash stockist slash dealers, etc., and not the end user. End user slash consumer. Full stop. Next paragraph. The facts relating to the present case, the facts relating to the three cases is that e-procurement notice dated 29/9/2023 had been issued by the Agriculture Department for supply of various items. Full stop. For supply of it was different notice e-procurement.
three tender notices on three, my lord, articles.
Okay, full stop.
The
Just say e-procurement notice, just say NIT, just say NIT, yeah, better. NIT dated 29/9. What have I said? And is that NITs dated, NITs, NITs dated, full stop. In WPC 6588 of 2023, comma, the NIT, no, not the NIT, it's NIB, notice inviting bids, NIB, dated 29/9/2023, was with regard to the supply of micronutrients and agricultural lime for the year 2023-24. Then, full stop, in WPC number 6589/2023, the NIB dated 29/9/2023 was with regard to supply of biofertilizer for the year 2023-24. In WPC 6591/2023, the
Pesticides and
NIB dated so was with regard to supply of
pesticides and weedicides.
pesticides bracket chemical comma bio and botanical bracket close and weedicides WEEDICIDES for the year 2023-24. Next para. Wait, huh? Two point 5.2 of the instruction to bidders bracket ITB required the bidders to be of one of the following three entities to be eligible to participate in the bidding process. Number one, manufacturer of the goods, or two, authorized dealer or distributors of the manufacturer of the goods, comma, or number three, Roman 3 small, authorized importer of the manufacturer of the goods. This is at page 31. The first. Next para. Thereafter, the respondents issued corrigendum -1 dated 19/10/23, wherein a further condition was inserted into the NIB dated 29/9/23, which required that the manufacturers should also have experience. Acha, in the earlier thing, the others also were supposed to have in the experience clause.
Yes.
Was it there in the NIB for the
No.
for the dealers and the for the dealers?
Yes.
Was it there in the? It was there
Yes, for dealers. it was there.
for dealers only. Where is that in that thing? Page 20 is the NIB.
Yes.
Where is that?
It's page 55, Your Lordship.
Page 55. Okay. Just before that corrigendum part, just before that corrigendum, just put
Clause 4.2.1.
clause 4.2.1
Yes.
of the ITB. No, ITB, what is it?
The NIB.
Of the ITB required the bidders, comma, excluding the manufacturer of the goods offered, bracket close, no, bracket, comma, to have experience in supplying goods of similar nature of at least 20% quantity to any government department / undertaking / entities / PSUs during the last 3 financial years, comma, that is 2021 to 2022-23, ending on the last date of bid submission. First up. Then the corrigendum will come. Then what is the last I said? What have I said? It just said number one, this is corrigendum -1. That the manufacturers should also have experience in supplying of at least 30% quantity of quoted items to any government departments / undertaking / entities / PSU within the last 5 financial years, that is 2018-19 to 22-23. This is also why, again, more for them 5 years, for dealers only 3 years.
No, not subsequently for everyone 5 years.
5 years.
5 years.
Next, then. Next. The learned senior counsel for the petitioners submits that the reasons given by the reason given by the state respondents in issuing the corrigendum requiring manufacturers to have experience in supplying materials to the government had been done in consonance with the standard bidding form, standard bidding document, (SBD), which had been inadvertently missed out at the time of issuance of the NIB. However, the requirement of manufacturers to have experience in supplying materials to government is absent in the SBD. As such, the very basis for making the corrigendum incorporating the additional condition on the manufacturers to have experience in supplying items was arbitrary, as there was no basis for the same. That's all. Anything else? Next. That is not exactly your pleading. Not exactly, but there is a pleading a little bit. Huh? That's all I think. Anything else you want to put? I don't think there's anything else. Next. Mr. No, do I incorporate your citations?
Your Lordship may, my lord.
Huh?
Your Lordship may.
I don't find it very, anyway.
Ultimately, the end result
Huh?
matters. Ultimately, the end result matters, my lord.
Yes, it makes the judgment very long, that's all.
Your Lordship may speak it.
I can put it, but then I don't think it's applicable to the facts of this case. It doesn't really hit the point. I don't know, no. Subject to what you say. According to you, it hits the point. It's to the point.
But these the judgments say that it cannot be arbitrary, although they may be the author, but it cannot be arbitrary. That is to that part only. Nothing more.
Okay, right.
And essentially, ancillary.
The counsels for the parties submit, the counsels for the petitioner, the senior counsel for the petitioners submits that the condition incorporated by way of the corrigendum is only an ancillary condition and not a essential condition. And as such, the state respondents would have to consider the bids of the petitioner. Pushkar. He also submits that the decision of the respondent authorities to incorporate the subsequent condition in the corrigendum being arbitrary and without any basis, the same should be set aside.
And my lord, we have been sought to be ousted and to the benefit of the my lord, suppliers and bidders.
He also submits that the manufacturers would be having the best competitive rates in a bidding process, in a competitive bidding process, and the attempt by the state respondents to oust the manufacturers from competing in the tender process gives rise to an inference that the same has been made with a view to favor
The dealers and distributors.
Huh?
Dealers and distributors.
dealers and distributors who would be having who would be submitting higher bids, keeping in view the commissions to be commission/profits to be made by them. In support of his submissions, the learned counsel for the petitioner has relied upon the judgments of the apex court in 2016 12 SCC 632, 2016 16 SCC 818, and 2021 16 SCC 808. It is here. It's this. That's on top.
Worship may also incorporate that my lord, more than one Sharma.
That I will incorporate since it came from me. Isn't it? Next, Mr. D. Chakrabarti, the learned counsel for the Agriculture Department, submits that the corrigendum had been made as the experience required of a manufacturer for supply of quoted items in a tender document had been inadvertently omitted at the time of issuance of the NIB dated 29/9/2023. The unintentional omission was accordingly corrected after suggestions to the same had been brought to the notice of the Department Bid Committee. He submits that clause 4.2.1 bracket Roman 2 small, in the standard bidding document bracket SBD required the manufacturer of a quoted goods manufacturer of coated goods to have valid manufacturing license and and the experience of manufacturing and supplying of at least 3 financial years. However, the period of experience for supply of materials was relaxed to 5 years so that more bidders could participate in the bidding process. The Learned Council has also reiterated para 4 bracket E to state that not to in no to submit that a man the man the petitioners are required to have experience of manufacturing and supplying of the materials for at least 3 financial years. Oh, right. I've got a full bench. Now we've got a full bench. The financial. Wait, I'll just finish your part at least. Just a minute. Otherwise, it'll be a problem. Then, anything else besides that? I think that's all.
Lordship, basically,
Next,
is
next
126, Lordship.
126. Which part?
The third paragraph, Lordship. Summarizing the whole paragraph.
He submits that page 126, that from that although till here, okay. I have put it till to gauge the supply experience and capability of the manufacturer. It's in the middle. Okay. Next. The petitioner's counsel, no, the counsel for the no, up to the second one, 30%. Okay. In support of his submission that judicial review of the terms of a tender cannot be undertaken by a writ court, he has relied upon the judgment of the Supreme Court in Dash versus Dash, 2004, 4 SEC 19. Full stop. He also submits that the courts should not use a magnifying glass while looking into the terms and conditions of a tender notice, and that courts should not substitute its decision from the decision of the tender committee. From the decision of the state respondents in the making of a tender notice.
Yes,
In the making of a tender, in the making of the clauses of a tender notice. First up, in this regard, he has relied upon. Now, in regard to the above submissions, he has relied upon 2020 16 SEC 489 and 2022 5 SEC 36. First up. He also submits that a judicial review cannot be allowed when there is no arbitrariness in the making of the tender notice and the corrigendum. And in this regard, he has relied upon the judgment of the Supreme Court in Dash versus Dash, 2023 SEC online. SC 671, okay. He accordingly submits that the writ petition should be dismissed as the petitioners do not have the qualification of experience in supplying the quoted items in the NIB. That's all. I have, first off, I have heard the learned counsel for the party, okay? Now you give that to me. I don't know how you're gonna give them. Huh? How you're gonna?
My lord, item number 6, my lord, very thick, my lord. Very thick, my lord. On 13th or tomorrow, they contain.
Tomorrow, no, tomorrow,
13th, in the 13th. 13th.
13, list the matter on 13. How when? Okay, then.
Because 18 to
7
20.
wheeler kind.
आगे तो अलग से रहेगा, हाँ? अलग से रखा ऐसे ऐसे किताब के साथ हाँ what is that unlisted?
I think 7 wheeler kind. Same with item number 22. Because parties are different and I work it.
No time, Mr. Council, tomorrow.
I think 7 wheeler Friday.
Tomorrow no chance, only that.
Then the 13 wheeler.
18 to 20.
13.
18 to 20 may be taken up 13.
We were just deciding whether we are on the same side or.
So what was the decision? So what did you all decide? Are you on the same side or on opposing sides?
I think we are on the same side.
My role is to try to assist your lordship, my lord, to come to a finding. In fact, my lord, I have prepared some notes, perhaps that may be of help, my lord, some compilation. One is, my lord, the position before 44th amendment and the after 44th amendment. And then a comparative analysis of the views taken by different high courts on either side. And of course, my lord, the Amendment Act itself, that 44th amendment. This documents may be of some assistance, but I may place them.
The same thing, you do the same thing.
No, the three sets have been. Set one of the rule is.
Means we are getting two sets of same thing.
No, we have prepared my three sets of this matter to give the worship. I think the sorting or shout out has been made. My lord,
Two 42nd amendments are there.
no, my lord, 142nd amendment, then one.
But I know 44th amendment. 44th amendment is also two.
I think this is the one of the.
Correct. Simply, this I've got. Like these three. I know.
Three items.
Three items, no? So this is, I think,
This should be the. 44 amendment.
44 amendment.
This is the second one.
Yeah.
This is the property.
Yeah. The 1, 2, 3, 4. So he's got.
I'm sorry, my lord, There was some mistake in sorting.
Okay, later.
Basically, my lord, as I understand, my lord, there are two lines of interpretation of the clause, of any clause really. One is that literal construction, the other is the purposive construction. Now, 44th Amendment, perhaps, my lord, a reading would be helpful.
Yes.
May I read my note, my
There are lawyer from Nagaland. Yes.
May I read the note?
Yes.
A statement of objection reasons appended to the Constitution 44th Fifth Amendment Bill 1978, which was enacted with the Constitution 44th Amendment. To statement of objection reasons. Recent experience has shown that the fundamental rights, including those of life and liberty, granted to citizens by the Constitution are capable of being taken away by a transient majority. It is therefore necessary to provide adequate safeguards against the recurrence of such a contingency in future and to ensure the people themselves an effective voice in determining the form of government under which they are to live. This is one of the primary objects of the bill. It is therefore proposed to provide that certain changes in the Constitution which would have the effect of impairing its secular or democratic character, abridging or taking away fundamental rights, prejudicing or impeding free and fair elections on the basis of the adult suffrage, and compromising the independence of judiciary can be made only if they are approved by the people of India by a majority of votes at a referendum in which at least 51% of the electorate participate. Article 368 is being amended to ensure this. In view of the special position sought to be given to fundamental rights, the right to property, which has been the occasion for more than one amendment of the Constitution, would cease to be a fundamental right and become only a legal right. Necessary amendments for this purpose are being made to Article 19 and Article 13(1) is being deleted. It would, however, be ensured that the removal of property from the list of fundamental rights would not affect the right of the minority to establish and administer educational institutions of their choice. Similarly, the right of persons holding land for personal cultivation and within the selling limit to receive compensation at the market value would not be affected. Property, while ceasing to be a fundamental right, would, however, be given express recognition as a legal right. Provision being made that no person shall be deprived of his property save in accordance with law. Now, this is important. A proclamation of emergency under Article 352 has virtually the effect of amending the Constitution by converting it for a duration into that of a unitary state and enabling the rights of the citizens to move the courts for enforcement of fundamental rights, including the right to life and liberty, to be suspended. Adequate safeguards are therefore necessary to ensure that this power is properly exercised and it is not abused. It is therefore proposed that a proclamation of emergency can be issued only when the security of India or any part of its territory is threatened by war or external aggression or by armed rebellion. Internal disturbance not amounting to armed rebellion would not be a ground for the issue of the proclamation. Further, in order to ensure that proclamation is issued only after due consideration, it is sought to be provided that an emergency can be proclaimed only on the basis of the written advice tendered by the president to the president by the cabinet. In addition, as a proclamation of emergency virtually has the effect of amending the constitution, it is being provided that proclamation would have to be approved by two houses of the parliament by the same majority, which is necessary to amend the constitution, and such approval would have to be given within a period of 1 month. As any such proclamation would be in force only for a period of 6 months and can be continued only by a further resolution passed by the same majority. The proclamation would also cease to be in operation if a resolution disapproving the continuance of the proclamation is passed by Lok Sabha. 10% or more of the members of the Lok Sabha can request a special meeting for considering the resolution for dispensing proclamation. Any further check against the misuse of emergency provisions and to put the right to life and liberty on a secure footing, it would be provided that the power to suspend the right to move the court for enforcement of a fundamental right cannot be exercised in respect of the fundamental rights to life and liberty. The right to liberty is further strengthened by the provision that the law for preventive detention cannot authorize in any case detention for a longer period than 2 months, unless an advisory board has reported that there is sufficient cause for such detention. An additional safeguard would be provided by the requirement that the chairman of the advisory board shall be a serving judge of the appropriate high court and that the board shall be constituted in accordance with the recommendation of the chief justice of the high court. A special provision is made guaranteeing the right of the media to report freely and without censorship the proceedings of parliament and state legislature. The provision with regard to breakdown of the constitutional machinery in the state is being amended so as to provide that a proclamation issued under 356 will be enforced only for a period of 6 months in the first instance and that it cannot exceed 1 year ordinary. However, if a proclamation of emergency is in operation and the election commission certifies that the extension of the president's rule beyond the period of 1 year is necessary on account of difficulties in holding election to the legislative assembly of the state concerned, a period of operation of the proclamation can be extended beyond 1 year. This is subject to the existing limit of 3 years. This change would ensure that democratic rule is restored to the state after the minimum period which will be necessary for holding the election. With a view to avoiding delays, it is proposed to amend Article 132, 133, 134 and insert a new Article 134A to provide a high court that a high court should consider the question of granting a certificate for appeal to the Supreme Court immediately after delivery of the judgment, decree, final order or sentence concerned on the basis of the oral application by a party if the High Court deems it so fit on its own motion. Case of special leave to appeal by Supreme Court will be left to be regulated by Article 136. The other amendments proposed in the bill are mainly for removing or correcting the distortions which came into Constitution by reason of amendments enacted during the period of internal emergency. The bill seeks to achieve the above object. The note on the clause explains in detail the various provisions of the bill. Well, look, this objection reasons, last page, paragraph 4, amendment of Article 226 in Article 226 of the Constitution. In clause 1, for the portion beginning with the word "rich in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them," and enabling the words "such illegality has resulted in substantial failure of justice," the following shall be substituted, namely, "rich in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any one of them, for the enforcement of any legal rights conferred by party of and for any other purpose." For clause 3, 4, 5, and 6, the following clause shall be substituted, namely, where any party against whom an interim order, whether by way of injunction or stay or in any other manner, is made on or in any way proceeding relating to a petition under clause 1 without a furnishing to such party copies of such petition and all documents in support of the plea for such interim order, and B, giving such party an opportunity of being heard, makes an application to the High Court for the vacation of such order and furnishes a copy of such application to the party in whose favor such order has been made or the counsel of such party, the High Court shall dispose of the application within a period of 2 weeks from the date on which it is received or from the date on which the copy of such application is so furnished, whichever is later, or where the High Court is closed on the last day of that period before the expiry of the next day afterwards on which the High Court is opened, and if the application is not so disposed of, the interim order shall, on the expiry of that period, or as the case may be, the expiry of the said next day stand vacated. Clause 7 shall be remembered as clause 4. Now, your lordship has seen, I have read the entire object and reasons. Nothing has been stated about why this article 226(3) has been amended, why this amendment has been brought in. Now, several questions have arisen out of this. And in that view of the matter, there are contrary decisions of the different high courts. I have given the list of the cases and the gist of the cases that have been decided. I am not going to that at that point of time, but then, my lord, your lordship will consider what is coming to my mind. A time frame has been fixed. This the writ petitioner comes before the writ court, files an application, and being satisfied, this honorable court passes an interim order. Now, when an application for vacating an interim order is passed, is filed, and it has to be taken within 14 days. Now, this is coming, I'm just thinking aloud. The party which has given the application for vacating the stay order, it may have brought some new materials, either showing that some things were concealed or that all facts were not placed. Therefore, the perhaps the right also accrues to the writ petitioner to rebut those statements. And in the process, the 14 days passes by. That situation has not been taken care of. This is one aspect that is disturbing my mind. Otherwise, when an interim order is passed by the Honorable High Court, there has to be a prima facie satisfaction, otherwise the order would not have been passed. New materials coming in from the other side, and the writ petitioner does not get an opportunity to rebut that. That is one disturbing aspect, perhaps. And if we go to the order passed by Honorable Justice, written by Honorable Justice and Silo, the last part, this penultimate part. No. Silo. Last part. No, referring the matter to the full bench. No, what is sorry, what is saying? I'm sorry.
I was thinking also, what judgment is he talking about?
It's a very long judgment.
Yes.
That was the facts are such, it was regarding a particular date on which the application for vacating the stay order was filed. That was a little in dispute. On records, it was shown that it was served on 21st of January 2020. But it has been, respondent has said that it has been received on 31/1/2020. Therefore, the situation is completely different whichever date is taken. From the record, it is shown that 21st of January is the date of service of the copy, but the submission was that 31/1/2020 was the date when it was received by the writ petitioner. As a result, we went the for sale date when the 14 days time expires. On that, the court accepted the 31/1/2020. Therefore, this question actually perhaps could not have arisen. No, I'm not criticizing the judgment. I'm just placing before lordship. Finally, refer to the
Anyway, you see, without going into the facts of each case.
No, I'm not going to the facts.
The basic question is whether it is mandatory or directory. And the law relating to it, and of course, we'll have to look into the various examples of what might happen, might not happen. So we'll have to confine ourselves, I think, slightly to that.
I'd just like to draw your lordship assembly's attention to his lordship's observation at para 103. No, this is the decision that has been taken. We apparently hold that even though there are facets of law which support the view that clause 3 of the Article 23 of the Constitution is mandatory in nature, there are more overwhelming attributes as discussed above to show that this provision is directory in nature. Then finally, in paragraph 103, just the observation, Mother, I'd like to read that. We'd also like to observe that since we have taken the view that clause 3 of Article 226(3) is directory in nature, as opposed to the view taken earlier by our own High Court referred to above, we deem it appropriate that it is this issue may be referred to a larger bench, for which we direct the registrar to place this matter before the Honorable Chief Justice with the request to constitute a larger bench to decide as to whether the provision of clause 3 of Article 226 are mandatory or directory. What my submission is that it has been held to be mandatory was by an honorable single judge. And
no, by division bench.
The earlier decision might, yes.
Division bench.
But in this case, it was by an honorable single judge. Anyway, my lord, your lordship, I have placed all the case laws regarding directory and mandatory, and the more we read, we find that the arguments in both the sides are acceptable.
No, that is why, you see, maybe we've got to look at things in a different way. I do not know. That's why we need your help. One thing is that 226 is a discretionary jurisdiction, a power given to it. It being a discretionary power, how do we look at the provisions contained in 226? Is a part of the discretionary power taken away by the subsequent clauses, by the subsequent clause in the articles? I mean, there are many ways of looking at it. I don't know. That may be one way.
And all the more because of the fact that one of the object and regions do not state anything about 226(3).
Mr. Chaudhary, you see, we have looked into the statement of objects, as well as I have just gone through the various judgments. You have we also have a full bench of a Gujarat High Court. I think wherein it has been held to be mandatory. But the question involved is as to whether you have to give a strict literal interpretation to the provisions of the Constitution, more particularly procedural aspect of 226, which is the 226(3) is a procedural aspect.
Yes, yes.
Or should you give a purposive interpretation?
Yeah.
Now, if you see a recent trend of the judgments of the Supreme Court, it will show a purposive interpretation is being sought to be done.
Right.
And more particularly, if you see the judgment, in fact, there is, although that is in respect of a statute, that is Section 254 of the Income Tax Act, it's a Pepsi Holdings Limited, I suppose, was the CIT. the Delhi High Court there is a provision, section 254, which say that if the hearing cannot be completed within a particular period of time, the appeal would be dismissed. Then the Delhi High Court say that particular provision has to be read, that it has to be at the fault of the assessee, of the person who has filed the appealant. So this was approved by the Supreme Court again in another judgment, I think in 2021. Justice, it's a 3 judges bench. Can we incorporate that aspect of the matter in this aspect by bringing in the purposive interpretation?
Yes, I understand your worship. My submission will be, earlier to this amendment, there were fetters on the High Court. And this amendment has removed that. And as your worship has said, my lord, this is a discretionary power. And in that event, the purposive interpretation will perhaps, that is what is the my lord, required. Because of the fact, my lord, in every writ petition, at least 50% of the writ petitions interim orders are passed. So if all these cases are to be listed on filing an application for vacation, because that has to be by a private party, because state is heard when the interim order is passed, then there will be a great load on the High Court, because procedural aspect we are saying, and in this context we can draw reference to Civil Procedure Code, Order 39.
In fact, the earlier proceedings, earlier provision prior to the 44th amendment was akin to the Order 39.
Yes.
Order 39 Rule 3A. So which stipulates that you have to give notice and all these things, whatever. But another aspect which is very relevant out here is this section, Article 226, which you are saying. It will mostly apply in matters of where only the respondent happens to be a private party.
Yes.
Or doesn't have a standing house.
Yes.
Then in such circumstances, otherwise, if we apply, just for example, the respondent is the government and the beneficiary happens to be a private party, then in that case, I think the 226(3) cannot apply, because if we apply 226(3) and thereby vacate an order which has been passed by the government, who were duly heard,
yes,
then under such circumstances, the application which has been filed by the private respondent, the benefit goes to the respondent, official respondents.
And that is why, my lord, perhaps otherwise, my lord, the power of the High Court under 226 or 215, this is unfettered. So if 226(3) is taken as literally, then perhaps that will be better from the
Reading of the Rajasthan High Court judgment, I think that might serve a purposive interpretation, because what has been stated out here, the word makes have been taken that the making to the court.
Yes, that
which
is
is
also
very
another.
relevant. Then the court is in session of the matter, and the court can very well take a decision. It is then doesn't fall upon the registry for not listing, but it is then upon the court. So that is the opinion which has been given by the Rajasthan High Court.
Yes, Rajasthan High Court. That my lord.
The make an application has been said to be making an application to the court when the court is in session of that application. And then within that 14 days, you are to dispose it of.
Yes.
I think that is one of the very, that would be a possible thing to that effect. Then in that case, the word make has to be understood in that sense if it is done. The entire judgment of the Rajasthan High Court needs to be looked into. But that is another way out. Thereby
Yes, your worship is right, my lord. Only one paragraph I read from the judgment. The Honorable Rajasthan High Court, while reading into provisions of Article 286, has also observed that the paragraph 33, the expression High Court in clause 1, 2, and 4 has been used to indicate the judicial side or the seat of the High Court. Even in clause 3, the expression High Courts clearly indicates judicial seat of the High Court, subject to course to some confusion regarding the first such term existing in the second line, namely application to the High Court. Some courts have taken it to be referring to registry of the High Court to conclude that If an application has been filed under Article 226(3), the interim order will stand vacated regardless of the fact that the application has not come up for consideration.
And therefore, the word make has been taken as making to the court.
According to this court, term High Court used in second line of clause 3 of Article 226 cannot be read as registry of the High Court. Ordinarily, the rule of construction is that the same expression, whenever it appears more than once in the same statute, more so in the same provision, must receive the same meaning unless the context suggests otherwise. Another Supreme Court case has been relied on. The phrase used is makes an application to the High Court. The word user makes an application and not files or submits an application in the registry of the High Court. Accordingly, the phrase used in clause 3 makes an application to the High Court should be construed to mean the application to the court hearing the matter when the application is taken up for consideration by the appropriate bench of the High Court. Merely moving or filing an application in the registry of the High Court cannot be treated to be an application made to the High Court.
That seems to be a more purposive thing.
Yes.
They were protecting the rights of the others also.
Yes.
Anyway. So anyway, I think we have to have another day because it will take some time. The Nagaland AG might have something to say. Preliminary submission on this aspect. What is your?
Well, I feel that an amendment of this nature to one of the most important articles of the Constitution, which is almost equivalent to the parameters of Article 32, in fact, which is even more than that. You are introducing an amendment in the form of 226(3), 44th Amendment, without any discussion, and merely state it is to avoid distortions. In fact, it has created distortions because we are not clear what they had in mind when they introduced this amendment. That is why we are having so many types of views from so many courts. And if I'm not mistaken, this matter is pending also, and the judgment is reserved in the Supreme Court. And I just brought that to your lordship.
But Malakum, I don't think the matter is pending in the Supreme Court. In fact, that matter pertaining to the Asia resurfacing, you must be referring to that. There was an argument being made where Justice Mr. Vijay Hansariya had submitted that kindly take up this matter, but the Constitution bench said that we are not. We are only going to look into this because of Mr. Rakesh Dwivedi and Mr. Tushar Mehta said kindly don't take up this issue of 226(3). So therefore, that was not taken.
But I have gone through the submissions made by various persons here. I think that may throw some light. This is my humble submission. And I think this it's very difficult for us to come to an analysis on this. The basic problem with this is that we are not clear why they brought this amendment. We are not clear. Now, it's more a procedural amendment. Procedure. This is not substantive. They're only saying, what are they saying? You get a stay if certain parameters are complied with. Prima facie case, whatever it is, all those three parameters are complied with, then an injunction or stay is granted. So it's a judicial order. Now that judicial order is nullified by a procedure which does not stand to reason. Automatic. So it is self-defeating. In spite of all these judgments, my humble submission is that it is self-defeating. 226(3). Even its validity has to be gone into, whether it's constitutionally valid or not. How can this procedure take place in such a beautiful constitution? that you file an application 2 weeks or so, and then you get away with it. That's not the intent. Something went wrong. Just like your lordship has said about that income tax 250, I think that's the Pepsi case. You know that Pepsi. There they made similar thing, that if you don't conclude within 1 year, then the matter is over. Everything gets discharged. So that has been corrected by the Supreme Court. So the court is going to correct it from time to time. Instead of correcting it from time to time, we have to reassess the constitutional validity of this article. That also this honorable court may look into. Because it is important. Why we are having so much confusion? All are given by learned judges. They've reasoned it out, but still there is confusion. Distortion is the word used, to remove distortion. No discussion. This is what happens when you go in for any change in the constitution without discussion. It's unheard of. Maybe when the 44th Amendment came, which was a type of retaliation to the 42nd, many things might have happened in haste. They may not have understood at that time what its actual implications are. And that is being faced today. These things can be looked into sometimes. About the orders also on the Supreme Court, where it is written that judgment reserved.
Which one?
The Supreme Court judgment constitutional bench.
Has the judgment been delivered? No.
Not delivered. I've been watching it.
No,
Judgment
I
reserved.
saw the transliteration, transcription.
Correct. You won't copy.
But I'll just tell you something, my lord. You see, what has happened is insofar as chapter 5A is concerned of the Guwahati High Court rules, it deals with applications under Article 226. Now, there are several separate chapter, which is chapter 8A for election petitions. And in election petitions, there is a provision, Rule 10. It says all interlocutory petitions should bear a court fee stamp of ₹6 thereon and may be filed before the judge with permission of his lordship. Now, this in one of the matters was interpreted to mean that filing before the judge is just not permissible. So therefore, we said that the filing of the registry would also include the court. So therefore, the court would include not only the judges, but it will also include the registry and the filing section. So therefore, what happens is that there's another way of looking at it. Like order 821 says that written statement should be filed within a specified time. If it is a regular suit, then they said it is not mandatory, it's directory. But when it comes to commercial suits, the Supreme Court has interpreted it saying that it is mandatory and therefore must be filed within 120 days. And therefore, if not within 120, it is lost. So therefore, procedure part is for the same provision is being dealt with when it comes to two different jurisdictions. So it's not that the judicial interpretation was given and then stay was granted, and therefore procedurally it is taken away. So even
that's right. But this particular provision is specific to Article 226. Only 226. That's the problem. And 226 has a large variety. And there is some discussion also on.
There is another aspect.
Criminal law also on this.
There is another aspect. When I was there, matter came up before the court, 226(3). And the honorable judge found that this, without going into the questions of interpretations of the provisions of 226(3), what could conveniently be done was that the stay was vacated. And then a fresh injunction was granted because of the fact of the facts and circumstances which warranted that otherwise the illegality should be, gross illegality would be given a stamp of approval. And therefore,
the stamp of removal court could not give. And thus, a fresh injunction was cast.
Anyway, so now, how do we go about this? I think some more reading, some more submissions maybe will have to be made. And like you all have rightly said now, no reason is there for this 223 to suddenly come and with one swipe take away the orders passed earlier, which are supposedly reasoned orders. Huh? Oh, yeah. Iralu is appearing for this council is appearing from Nagaland. Yes.
Yes, actually, I'm for the appellant, your lordships. But if your lordships require the assistance and regarding the reasons carrying on from what the learned AG has stated, that I can provide some of the Lok Sabha debates which happened before the 44th amendment as well as the 42nd amendment were introduced, just to assist this court as to with what intention these clauses were introduced.
Sure,
But
sure.
those-
But not, I think some other day will
Yes,
be.
your lordship. Yes, your lordships.
So any documents that you want to send, you please send it to
Your
the
lordships.
court master.
I'll do
Okay,
that.
then we can incorporate it there in the record.
I'll do that, your lordships.
I think because we cannot rush with this case, that's for sure. It's going to take some exercise. And I think we'll have to do a little bit of reading, everyone. So when can you both find time to come again? Sometime after?
Have your lordships, Derek.
AG can, because they're coming from Delhi and
Sometime next month is okay with it.
when?
Maybe after 27th.
Oh, my God.
If that's too late, then maybe you can have it on 4th. 4th may be too short a time. 4th I'm coming here, but we can have it on some other day. Your lot.
What do you say, brother? Fifth? Fifth? Is fifth okay for you?
Fifth.
Because March end, though, it might be a problem. And you might not be here. Okay, we'll fix it on the 4th. Or 5th. 5th at 2 o'clock? 2? I think we can do some proper hearing. Okay. The learned advocate general, Nagaland, is present along with Mr. M.K. Chaudhary, learned senior counsel. Let's this matter again on 5/3 at 2 p.m.
Mr. Iralu is also.
Oh, Mr. Iralu, L. Iralu appears for the appellant. We put him in the number 1, huh? Through video conferencing. This is the matter on 5/3 at 2 p.m.